Okay, we're just waiting for a moment. Good morning. Today we continue this second week of our two-week hearings on the priority areas of child protection and the criminal justice system. There is an overlap between these areas, as you will be describing to us as well, Vicky, and I just want, before we commence, to ask Commissioner Hunter to do the welcome to country and acknowledgement of country.
Thank you, Chair. So I'd like to acknowledge and welcome everyone here to the lands of the Wurundjeri people, my ancestral lands, pay our respects to elders, past and present, and acknowledge those that have come before us so we're able to give voice here today. Sir Wominjeka.
Thank you, Commissioner Hunter. Council appearances, please.
Thank you, Chair. Council assisting today, I'm being led by my leader, Mr McAvoy, and Fitzgerald, Council assisting. And the state is represented by Gemma Caffarella today.
Good morning, Commissioner.
If the Commission pleases, I'll now call today's first witness, Auntie Vicky Roach, who's appearing remotely.
Thank you, Council, and welcome again.
Thank you. Auntie Vicky Roach, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes, I do.
Auntie, will you introduce yourself to the Commissioners?
My name is Vicky Lee Roach. I'm a proud Yuin woman. I'm currently living on Yuin land, although I was brought up in the western suburbs of Sydney with foster parents, with white foster parents. I ran away at a very young age and have lived in many places all over the country, but this is my country, Yuin country, down here on the south coast of New South Wales.
Thanks, Auntie. Today I wanted to ask you about the past and about the future, because your insights into how things should be done in the future are very much informed by your past, and that is your experience of being separated from your mum at a very young age, of being a ward of the state, of heroin addiction and the crimes that you committed to service that addiction, of being a young person in prison and withdrawing from drugs in prison, of having your own child removed and of fighting to get him back. For the last week and a half, we have heard evidence from Aboriginal and other organisations about child protection and the criminal justice system, and we are absolutely privileged to have you give evidence of your first-hand experience of those systems today. If we can start at the very beginning, you're a member of the Stolen Generations. What happened? What happened when you were very young?
When I was very young, my mother had myself and a younger half-sibling, and she was pregnant again, and she had to go into an unmarried mother's home, even though she was married by this time. And she had no family, of course, because she had been taken herself as a baby, so she really had nobody to go to. So she went to the only guardian she'd ever known, which was the Child Welfare Department, as it was known in those days. And because she couldn't take us to the home where she was to give birth at, so she had to leave us somewhere, and there was nowhere for her to go, so she went to the welfare department, and they separated me from my brother, and the receptionist of that office took me home like a stray puppy. But she didn't want the boy. She didn't want the boy puppy.
And from that point, you were made a ward of the state. Is that what happened?
Yes.
And you've said that during that period, your mum did maintain contact with you, but she was told to pretend not to be your mum when she visited you.
Yes. Yes. It was only the arrangement was only supposed to be for 2 weeks while she gave birth, but there were complications with the birth, and the baby, my little sister, was sickly when she was born. She had diphtheria, or she developed diphtheria soon after she was born while she was still in hospital, and so that I imagine would have all been very difficult. And then my foster parents went to court to get custody of me.
And if we can go... Sorry, Auntie.
They actually charged me on that day when I was 2 years old with being neglected by way of destitution and exposed to moral danger, I think was the other one, or neglect. No, it was neglect by way of destitution, and as a device to remove me from my mother.
So since once you got a bit older, you realised you had a criminal record from, I think it was 2 years old, which
Yes.
was the mechanism by which you were removed from your mother.
Yes, yes.
And can you've given some evidence in your outline of evidence about your later contact with the law, and I think you refer in your evidence to this trifecta of charges, which is being uncontrollable, being exposed to moral danger. There were these devices that were used in relation to Aboriginal young people. Can you speak to your teenage years and your interaction with the criminal justice system?
Well, it was in my early teenage years. It was mostly running away, and that would result in the trifecta: neglect, uncontrollable, and exposed to moral danger. But nobody would ever ask, like, why I was running away, or any number of the kids in the same homes I was being sent to. You know, none of them were being asked why they were running away.
Auntie, why were you running away?
Because according to my foster mother, I was trying to rise above my station. Yes, so I ran away to Nimbin. I thought that sounded like a good station.
And talk about your time there, and from the witness statement, your witness statement, it seems as though you started using heroin from a very early age. Will you speak to what you were doing at the time and how that happened?
That happened because of the end of the Vietnam War, and a lot of returned soldiers were coming back with very bad habits on heroin and would often bring heroin back with them, or have easy contact, easy access to it, I mean. So it became quite prevalent. It sort of hadn't crossed my path until then, I say, but it wasn't really that long. And to begin with, I wasn't interested because it involved needles, which, as a kid, I was scared of needles. But in the end, it was the suggestion that I was too young to have it. Sort of made me say, no, I'm not. I can do that. If you can, I can. So, I started using it, and it became a great panacea for everything.
Arnie, what was it a panacea for you at that time?
Panacea, pronounced that wrong. I knew I'd do that.
No, I'm not sure that I know how to say it properly either. But whatever that word is, what was it fixing for you? What was it giving you that was missing at that time?
A kind of ease, numbness, which most users will relate to. You can kind of forget about the things that have happened and whatever traumas you've experienced in your life. You don't seem so dreadful anymore, or for a while, and it's a good state to be in. It's self-medication, basically.
Arnie, at the point you start using, you're only 14 years old. What trauma had you experienced by that point?
I've been in the children's system and been subjected to internal examinations by the doctor at the holding centre for young girls, the Glebe Metropolitan Remand Centre for girls. And by that time, I'd also been raped as well.
You talk in your statement about the way in which your heroin use ended up having you involved in crime to support that habit. Can you talk about the connections between addiction and incarceration for you?
Well, incarceration, I neglected to mention the superintendent of one of the homes I was in, who was charged after the Royal Commission into institutional responses to child abuse. He was charged, I think he was 84 or something, so he's had a lovely long life. But yeah, I'm sorry, I was strayed from the question there.
No, Auntie. I was just going to speak to you about the evidence you've given in your outline about the fact that all of the crimes you committed were really to support that habit, and you have some views about the utility of prisons, and I'm interested in the extent to which you feel that it was really your addiction that saw you end up in prison. And can you just speak to some of the, what being an addict with an expensive habit required of you at that time as a young person?
Well, as a young person in particular, because I was unable to access any government services, like you couldn't get any youth sort of allowance or anything like that then. So I was basically, it was fine in Nimbin and in the hippie communes to have no money. It was quite different when I got back to Sydney, and I wound up doing sex work in King's Cross as a very young girl, which unfortunately had its advantages.
And obviously sex work at that time
had its advantages for me financially.
And so you ended up doing sex work to pay for your heroin addiction?
Yep.
And
to pay for everything, really. It had to. I had no other source of income. That was it.
And how old were you when you started doing that?
I would have still been about 14.
And how did
I even tried to get a job in an ice cream shop up there. First, I think it was the first 33 flavours in New South Wales or something, and they wouldn't hire me because I was too young and would have to do shifts at night time, Yeah, so there wasn't a lot of choice.
And how did you come in contact with the police, and can you speak to the first times you ended up being arrested and the results of your heroin use?
Strangely enough, King's Cross was, although it was where I was finally arrested and imprisoned from, for the most part, the police, or the detectives mostly, would ignore me because I was too young. It was, I didn't even hear them say it, I was too much of a hassle, because I was underage. So they'd basically ignore me. But then when I was 17, they decided not to, to stop ignoring me. Yeah, well, I was actually pulled over and arrested with no evidence, with no drugs on me, just track marks. They saw track marks on my arms, and they said to me that if I admitted to using heroin, that they'd get me help. And well, by that time I thought that sounded like a good idea, so I said yes.
And did they get help for you?
No, they just threw me in jail. And the magistrate gave me 6 months.
And you give some evidence about how you feel that 6-month sentence was affected by the fact that you had a very long criminal record since 2 years old, in fact, that
yes,
that had an effect on how you were treated at that point.
Yes, absolutely, 100%. It was highly unusual to sentence somebody under 18 to prison back then.
I might just pause, honey. I've been given a note. No, I just clear one thing up. Auntie, when we started, did I ask you if you were happy to undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes.
Good.
Yes.
I'm glad. Thank you. Sorry.
Yes. Yes.
And I will. Thank you. And I assumed you were. I will. When we get to the end, I will also ask you to adopt the witness statement, which has had some adjustments overnight, but I'll deal with that at the end.
Okay.
Sorry, Auntie.
Okay.
In your outline, you've given some evidence about the extent to which, at that point, addiction gave you a purpose and a community. Can you, at that point, as I understand it, you didn't know that you were an Aboriginal person?
No.
Can you speak to the role that addiction plays or played at the time in filling a void left by not knowing who you were?
It played a huge part, actually, because the drug community, it becomes a community. They're all people you know. You're part of that community. You belong. It's your network for local information. It's your family, basically. You know, good and bad. And yeah, I think that was that was probably a positive thing, and you could also take that anywhere you went, you know, any city in the country, and you'd find like-minded people, and you had a community of people to which you belonged. And again, I've sidetracked away from the whole purpose of that question.
No, you weren't, in fact. I just moved to your time in prison, and as I understand it, you first went to an adult prison when you were under 18 years of age.
Yes, of age.
And
yeah.
How old were you, and why did you end up in an adult prison? Do you know?
I was 17, and I think the magistrate was just trying to throw a scare into me, or I thought that at the time, because he remanded me first for 2 weeks to the prison without bail, and I thought that, and you know, of course, you talk to other women too, and I thought that was just, they were trying to throw a scare into me to try and keep me out of jail. And yeah, so it was pretty devastating to get sentenced and come back to the jail. I'll never forget when I came back and they put me back in the cell, the sound that the door made, you know, although I'd been hearing it for 2 weeks. But, you know, once I knew that was it, you know, I was going to be there for 6 months. Well, in those days it wasn't 6 months. It ended up doing 3 or 4 months because we had remissions back then. But yeah, once I was sentenced, it was yeah, that noise was just like heartbreaking.
You were in and out of prison for a period of 30 years, and apparently you have 125 convictions, which you think seems a conservative estimate.
Yes. Yes.
You spent numerous periods of time in prison. What is the longest period that you've ever spent in prison at one time?
The longest time I've ever spent in prison was the 6-year sentence I received in Victoria in DPFC, and was released on parole after 4 years.
Now, two of the rationales behind imprisonment are deterrence and rehabilitation. Did any of those prison sentences deter you or rehabilitate you?
Neither. And I've questioned this point of deterrence in the sentencing formula before, and it simply does not exist. A magistrate told me once that it was not so much to deter me from offending again as to deter the public from offending in the way I had. And I thought, well, that's just ridiculous. You know, like I've been pinched for shoplifting or something like that. And, you know, who's going to hear about my paltry $50 fine for shoplifting? You know, that's not deterring anybody. And it certainly wasn't deterring me, because whatever I was doing, I needed to do because I had to provide for myself.
We've heard some evidence over the last few days about the difficulties faced by people who are leaving prison after having been in prison for a long stretch, and the extent to which people can really become institutionalised by that. Can you speak to how it feels in those first days, weeks, months coming out of prison after being there for 4 years?
Well, look, it's kind of relative. You can be institutionalised in an even much shorter length of time. It takes very little to institutionalise someone, and of course, our jailers are trained in how to do that. And the institutions themselves are built to do that. They're designed to do that. I don't know what else to say, really. Yeah, that's...
So is your evidence that it wasn't just the 4 year stretch after which you felt
institutionalised? No, I was already institutionalised from the kids' homes, and from the kids' homes, basically.
And what does that mean for your life skills, for your ability to operate in the outside world?
Well, you have no life skills. You know, you have skills in conformity or deviousness to get around having to obey the rules, you know, or avoid stupid rules and stuff like that. No, there's nothing rehabilitative or anything in being institutionalised. If anything, being institutionalised, it de-skills people and in a way lobotomizes them into compliance and conformity, and it's you still feel institutionalized even though you're being the biggest rebel there is. You still feel institutionalized.
I wanted to move now to speak a bit about the future and about how you would like to see things change. But in doing so, I wanted to reflect on the fact that you are, you personally have managed to be, despite that institutionalisation, be outspoken. The fact that you are an erudite, intelligent, outspoken woman who has been imprisoned with addictions and are still able to speak about those things is unusual. It's fair to say that most women with your history are crushed by it. I wanted, given the voice that you have some very strong views about the usefulness of prisons, and I was hoping that you would...
Uselessness of them.
The uselessness. If you would explain your view of prisons, whether they're useful, and what alternatives you think the state should adopt for instead of prisons.
Well, as we know, and there have been so many inquiries and royal commissions, etc., ongoing with Dondale for juvies, or ongoing for a lot of places. But how many success stories do you hear out of prison? You know, like, okay, somebody did good and, you know, got a job or blah, blah, blah. But was anything achieved in stopping recidivism, for example? And there maybe it's like their period of time is 2 years. If you haven't returned to jail in 2 years, you're a success story. Now that's bollocks. Like, you know, if you return to prison at all, you would have to say prison was not a success. There are no programs that are rehabilitative in prison. They're all tendered for, and of course the cheapest tender, or the one that the Department of Justice favours at the time, is given that tender, with no proper evaluation as to how well these programs work. And particularly in the women's system, many of the programs are simply transposed from the men's prison into the women's prison with no adaptation or adjustment for the fact that we're women. For example, there was a violence program which was ideally for men who had anger management, was for men who were bashing their wives. And yet that's the anger management program they gave us. They gave women. You know, it was like but it ticked the box. And I think that's what too much of all of them basically, except for community-led Aboriginal programs that come into prison from time to time. All of the other services that are provided in prison are just box ticking and have no serious evaluations done on them to, for them to earn their continued funding or whatever. It's just their lowest price.
Arnie, you've given some evidence about the particular impacts of certain practices within prisons on women, because women prisoners have often had a life trajectory that is different from male prisoners. In that context, yes. Could you speak to, you gave some evidence in your outline of evidence about the impact of the process of strip searching that you experienced personally. Can you explain the process of strip searching and its impact on you and your understanding of its impact on a lot of women prisoners?
Well, when you realise that like around 90% of women in prison have been abused, physically, sexually, throughout their lives, as a child or as an adult. Strip searching is a particularly demeaning, belittling, terrifying, horrifying experience to have to endure. And the fact is it's not necessary. Where it's not necessary to demean women in this way. And it causes women to avoid family visits, things like that, because of being strip searched. It's like being raped. It's like being raped. You've got no choice. If you can't say, no, I don't want to take my clothes off. It's you understand that it's not your body anymore, it's theirs. Like if I said no during a strip search, they'd just grab me and throw me down and tear my clothes off.
Council, could Auntie please explain the association between family visitation and strip searching?
Yes, thank you, Commissioner. So what's the link between those? Why would one have an influence on whether you wanted to have a family visit or not?
For getting strip searched.
So do visits,
you would have to be strip searched before and after the visit. And for some women, that was so intimidating and traumatic that they would forego the visit rather than endure the strip search.
So is that a standard procedure that if you are having contact with someone from the outside world, you would need to be strip searched before or after?
Before and after, yep.
I also wanted to ask you about some evidence you've given in your outline of evidence about how culturally unsafe prisons are for women. Now, if prisons are not going to be abolished, or in the meantime, while we're working towards that, what do you think needs to be done to make prisons less culturally unsafe for Aboriginal women?
Well, health is a good place to start. They're not served. Well, no woman is served by the health systems currently installed in prisons, private companies again, private subcontractors from outside. So nobody's served by them. Aboriginal women can access the Aboriginal Medical Service, but are not told that they're able to. And there are basically no culturally aware or culturally competent medical practitioners within the jail. There used to be one that would come in once a month or something, but she stopped coming as well. It seems like when a program is working, they stop it.
I wanted just to touch briefly on some evidence you gave about comments made to you during the sentencing process about your Aboriginality. Can you discuss what was said to you and speak generally about this very complex, or about the identity issues that exist for the stolen generation and the way in which the judiciary, or in your experience, the judiciary has dealt with considerations arising out of your Aboriginality?
Well, because I'm white passing, as you can see, I think this magistrate might have thought that I should have taken advantage of that, but he said that in my case, the Justice Eames decision did not apply to me, and that I had in fact reinvented myself.
And what's this decision that the judge was talking about, this decision by Justice Eames?
That prison should be a last resort for Aboriginal people, given our history of colonisation and removals, etc., throughout our history.
So there are two things in what you've said. The first is that the court, in your case, didn't think those principles should apply because of how you looked, and then secondly accused you of adopting a new identity almost to take advantage of a sentencing principle. Is that what your evidence is?
Yeah, well, that's what I got from it. That's what I got from it. You may speak to the judge and he'll have been thinking something else entirely, but that's what I took from it. And as I think most people would, most reasonable people.
You've also given some other evidence in your witness statement about other aspects of the prison system that you consider are inhumane. One of those examples involves a car accident that you were in, and as I understand it, you'd been in a car accident and then were taken straight to Dame Phyllis Frost. And if you can explain what happened and the way in which you were treated in that process.
Well, actually, I didn't go straight to Dame Phyllis. I was in hospital for some time. For a period of some days, I was in an induced coma, which I didn't find out about until I went to court. When they did take me from the hospital, I could still barely walk. I had fractured ribs, cracked sternum, fractured skull, fractured wrist, internal injuries, and they put me in the leather escort belt, which is, usually used for violent, prisoners. It's quite thick. It's like a wrestler's belt, and you're handcuffed to the front of it. And so I've got a fractured wrist, and I'm handcuffed to that. And I've got this huge, heavy leather belt laying over the top of all these broken ribs and internal injuries. And they must have been managing the pain really well in the hospital, because once I got to the jail, and the pain started coming on, it was just like nothing else,
And my understanding,
there was no way of getting any relief.
and as I imagine a known drug user, what's your experience with trying to get pain relief in prisons?
Zero. Like, you have to be really, really good to get painkillers off them.
The last...
The best you can expect is Panadol. If you're lucky, you might get Panadol for it, but you won't get that for long.
That was actually an issue that the last issue I wanted to discuss with you was withdrawing from heroin in prison and any drugs of addiction. But as I understand it, in your case, you often, you have been through the process of withdrawing from heroin, coming into a prison. What treatment or assistance did you get on those occasions when you were withdrawing, when you entered the prison system?
Depending on which prison and when. The last time, zero. You get, you got something for 3 days and a few Valium, but the Valium would decrease every day until the third day you got nothing, or the fourth day you got nothing. So it was all pretty quick and did not do to alleviate the pains of withdrawals for most women.
So is it fair to say that it was a forced withdrawal and a forced rapid withdrawal?
Yes.
What do you consider would be a humane way to treat prisoners with addiction when they're imprisoned?
To be safely and humanely able to withdraw from drugs or just maintain them. Look, if we're going to have a world where all drugs are decriminalised or legalised, we have to start looking at it as something not where everybody has to be clean, but that we have to understand that people are all different and are, well, as in my case and the case of pretty much every single woman in jail, drugs are self-medication. It's the way we do it. Lacking the resources to be able to do it through doctors or services available in the community.
Chair, those were all of my questions. Do the commissioners have any matters to arise?
Just the last one, Arnie. Vicky, I'm just wondering that your last time was Dame Phyllis Frost, is that correct?
Yes,
so
yes.
That's where that rapid withdrawal happened?
Yes.
Okay, thank you. Just wanted to clarify that.
Yes,
thank you, Arnie.
No, I'm good.
Yes. Auntie, I wanted to ask you about the support that you got to develop and express your own Aboriginal identity. And you mentioned this in positive terms as something that was meaningful to you. I wonder if you could just expand or share with us the significance of being able to do that when in custody, and do you have anything to say to us about the significance of Aboriginal people in custody being able to express their own culture?
It's extremely important for Aboriginal people to be able to express culture in jail, and quite often we're not, well, more often than not, we're not given the opportunity to do so. And it happens for so many women. I've seen it so much. A lot of Aboriginal women seem to find their culture in jail through the other women, and through some of the programs that some of the good programs that go through the jails, and it's something I can remember thinking still was, why do we have to go to jail to learn our culture? Like, wouldn't this all be fixed if we still had our culture and didn't have to come to jail to learn it? So I think while we still have prisons operating, Aboriginal culture must be a huge consideration in this space, despite the fact that there are a few of us in comparison to the rest of the prison community. As we go through this process of truth-telling, we need to be able to express that in many different ways, and prisons being so non-transparent, I think we have to make a huge effort for that to be possible.
Thank you, Auntie.
I don't have a question for you, but I'd like to thank you for the dignity with which you've presented.
Thank you.
Sharing something
Thank you.
so painful for so many. What would you like to come? What would you like to have as a response to your evidence from people that are hearing your story today?
I would love more people to get behind the prison abolition movement. I think I've shown in my evidence, or I've tried to, that there is no good achieved in prisons. When it's portrayed that way, it's a portrayal, it's not real, it's the person's own doing that's got them, into whatever success they've achieved. And, they might have been in prison when they did it, but the achievement is theirs. And I would just like to see more healing places. I would like to see elders being able to pass knowledge on to our younger people and heal. We have to heal. You know, we're going through this huge process at the moment with the rest of the country deciding on our future. You know, we need to heal ourselves and be able to heal the generations who are still being damaged by this current system that society in general seems loath to dismantle.
Thank you. Your story is compelling. It's helpful, I hope, in an educational way, and it's inspirational. Thank you.
Thank you, Annie.
Thanks, Arnie. Chair, I will now tender into evidence the outline of evidence of Auntie Vicky Roach. There are some small additions to paragraphs 1 to 3 since the version that was circulated this morning that have come in from Auntie recently, and I'll tender that, and also the 2 documents referred to in it, attachments 1 and 2.
Thank you. They'll be entered into the exhibit, the next exhibit numbers. Thank you.
And Council, this is an open document, if I'm not mistaken.
It certainly is. Thanks, Auntie. Chair, if that's a convenient time for a 15-minute break.
Yes, please. Thank you. Thank you.
Thank you, Auntie Vicky.
Again.
Thank you.
We'll recommence at 11:15. Thank you.
Thank you, Chair.
Council, ready to go? Thank you.
Yes, thank you, Chair. Chair, I'm appearing as counsel assisting the Commission with respect to the next set of witnesses. They are witnesses appearing on behalf of the Victorian Legal Aid, or VLA, and I now call Louise Glanville, Dan Nicholson, Joanna Fletcher and Lawrence Moser. Chair, they are present in the hearing room, and I would just administer the oath. That's appropriate. Witnesses, I'll ask you each in turn your name and whether you undertake to tell the truth in the evidence you're about to give to this proceeding. I'll start first with Louise Glanville. Yeah. Could you just tell the Commission your name?
Louise Glanville.
And do you undertake to tell the truth in the evidence that you're to give to this Commission?
I do.
Dan Nicholson.
Dan Nicholson.
And do you undertake to tell the truth to the Commission in the evidence that you're about to give today?
I do.
Joanna Fletcher.
My name's Joanna Fletcher.
Joanne or Joanna?
Joanna.
And do you undertake to tell the truth in the evidence you're about to give to the Commission?
Yes, I do.
And Lawrence Moser.
Lawrence Moser, yep.
Do you undertake to tell the truth in the evidence you're about to give to this Commission?
I do.
Thank you. Now, Commissioners, I have asked and Louise Glanville, on behalf of the VLA, has agreed to make an opening statement, and I invite Louise to make that statement now.
Thank you so much. Thank you, Commissioners, and on behalf of all my colleagues here and of VLA, I'd like to acknowledge the traditional owners of the lands on which we're meeting, the Wurundjeri people, and pay my respects to elders past, present and emerging, and note that their lands have never been ceded. It's a great privilege to appear before you this morning, and my colleagues join with me in being very pleased to be here and to be able to talk to you about our evidence from Victoria Legal Aid. I'd actually like to them to introduce you to them, just and I'll ask each of them to say what their role is in the organisation, so you've got a sense of that, Lawrence.
Good morning, Lawrence Moser. Tanarung descendant, and I also pay respect to country and to elders past and present, and I pay respect to this process here today. Employed with Victoria Legal Aid as the Associate Director for Aboriginal Services, and been with the organisation now for a couple of years.
Thanks, Lawrence. Joanna?
I'm Joanna Fletcher. I'm the Executive Director of Family, Youth and Children's Law, which means that child protection sits within my directorate and I hold that responsibility.
Thanks, Joanna. Dan?
And good morning, I'm Dan Nicholson. I'm the Executive Director of Criminal Law, so responsible for all of Victoria Legal Aid's criminal law services across the state.
Thanks, Dan. And I'm the CEO of the organisation. I also hold the role of the Chair of National Legal Aid. National Legal Aid represents the 8 legal aid commissions around the country in states and territories as well. So I hold that role for probably about a 3-year period, and I'm just at the end of my first year. So I just wanted to talk a little bit about VLA, if I could, to start with. We're a statutory agency. Our independence is perhaps best described as decisions we make about who receives grants of legal aid and assistance. That's the sort of the core of it in my view. And we're responsible for providing information, advice and assistance in response to a broad range of legal issues that individuals would raise with us across Victoria. We've got about 1,000 staff and we are based across the state in both offices in Melbourne, in central Melbourne, suburban Melbourne and out in the regions of Victoria. 30 of our staff are First Nations people, so that is about 3%. We work alongside our partners as part of the legal assistance sector, so very importantly community legal centres, private practitioners, and for us most importantly for this purpose in particular at CHOS, so in relation to VELS, the Victorian Aboriginal Legal Service, and JIRA, and I know you've heard advice from their CEOs and their evidence yesterday and this week in relation to some of that work. The problems that we encounter, that people raise with us, really cover the whole gamut that you would expect individuals to experience in their lives. So criminal law, child protection, family violence, mental health, debt, social security issues, mental health, NDIS, discrimination, all of those areas we are involved in and have staff that support individuals in that work. Our clients are diverse and experience high levels of disadvantage, and our means test is very mean, so that we have a very low ability to fund the amount of legal need that exists in Victoria and nationally. And that's why it's important that we work together as a sector and that we support our partners in this work. We have a legal help, both a phone line and a web chat, which Victorians can seek information and advice from, also assistance with their legal problems. And we deliver specialist legal services as well at both the federal and state levels. And it's important to sort of, I think about the fact that we don't, not just at the tertiary end or when people are really in strife, but we also work in the prevention and early intervention space as well. And we have a number of non-legal advocacy services, such as our independent mental health advocacy and our independent family advice and assistance service, which are made up of non-legal advocates. So we support the model of legal and non-legal advocates working together and having the person at the centre of our work and working around and with their issues and concerns. A little bit about sort of our work in more detail. In 21-22, 7% of all VLA clients identified as being Aboriginal or Torres Strait Islander. 8.2% of these received a criminal law service from us, and Dan would be able to talk about more of that detail in terms of whether that was duty lawyering or remand duty lawyering or what type of service that was. And 17% received child protection services from us, which is quite a significant figure. Importantly, VLA uses the evidence we get from our practice with the proper consent from people, either de-identified or brought together in a way to really support policy and law reform and strategic advocacy and litigation. We can provide advocacy directly to government ministers. We often do that in a way which is not public around what we're seeing on the ground, but our Act also enables us to draw attention to the Attorney-General of issues that are of concern to us or things that we think need addressing, and we are particularly keen to also work with other ministers across government at both state and federal levels to really reflect the reality of the types of legal problems that people experience and how it's often connected to social disadvantage, poverty, and these areas. A good example of the way in which we use our evidence for broader systemic reform, because the legal aid fund is quite small, it is contributed to by both state and federal governments, but it would never meet the amount of needs that existed, and they're matters for government to think about. But generally, the best example in recent time is robo-debt. So Victoria Legal Aid took the 2 cases to the federal court that resulted in those decisions that indicated that the government was acting unlawfully in terms of the way it was collecting debt. We don't challenge the government's ability to any government's ability to collect debt appropriately, but in this instance it was an illegal, unlawful way of doing it in terms of their act. And this really was important because in that instance the Commonwealth Government's accountability for acting within its own legislation was compromised dramatically, as you would see from the current Royal Commission into robo-debt, which we've appeared with several of our clients some months ago, and also we'll be back before that Royal Commission talking about this matter in February. We also use our evidence to contribute to Royal Commissions and inquiries such as this and other examples of the Victorian Mental Health Royal Commission, the Royal Commission into the Management of Police Informants, which was a particularly important one for us, the parliamentary inquiry into the Victoria's criminal justice system, and as I mentioned most recently, robo-debt. And probably if I was to try and characterise all of that, I'd say from our practice experience in courts every day and every night, in almost every court across Victoria at federal and state levels, we see that the criminal justice and child protection systems are failing First Nations communities and perpetuating disadvantage and disempowerment. So that's why we have provided 2 submissions to you, one on the injustices in the criminal justice system and the child protection systems. And we identify what we think are urgent priorities for reform that need to be acted on reasonably quickly. And we also identify some longer term issues, so I'll just briefly touch on those. The child protection system, we see the need for urgent changes to enhance fairness and to support for families to stay together. And these include reinstating the Children's Court's ability to make orders in the best interests of children without time limits on reunification. Secondly, we are very keen, and our board has recently been out to Broadmeadows Magistrate Court and looked at Maramnala Gambu Koori Family Hearing Day, and we're very keen to see that specialist children's court statewide, so that the lessons that have been learnt there and the approaches to justice that are being used by both the staff and the magistrates that are sitting around that table can actually be replicated in other parts of Victoria. In the criminal justice space, we see the need for urgent reforms to keep First Nations people out of the justice system by maximising the use of cautioning and diversion, increasing the minimum age of criminal responsibility, reforming bail laws and other minor offences, and implementing a health-based approach to public intoxication. So these we see are really critical areas, as well as we see the need for building a self-determined criminal justice system which prioritises First Nations experience and knowledge and recognises their leadership in building culturally safe places, practices, services and institutions throughout the system. So this is ambitious, but it is what we must aim for. And we see that it's important to have some both short-term objectives here and some longer-term objectives as well. Many of these reforms that I've mentioned, I'm very sad to say, are not new. These suggestions are not new, and I think in some of our materials we've listed the number of times that there has been reports and recommendations around these issues. These recommendations have been across many years. I'm 62 now, and I can think about the last 20 to 25 years and count the number of reports that have touched on these issues. I won't be laborious and go through them all, but we can certainly give you some detail on that if you're interested. But we must all bear this responsibility, in my view, and ask ourselves why more changes have not occurred when we so well understand from our practice the nature and implications of many of the failures of these changes to occur for First Nations people. So there is a real urgency here, and that we need to embrace this and run with it in VLA's experience. We do acknowledge very much that the state government is working towards truth and treaty, and we are very pleased that the Premier Daniel Andrews last week acknowledged that too many First Nations children are being taken away from their families by the state, and that the government wants to see greater self-determination and greater Aboriginal control in the child protection system. This is a significant first step, but we need to think about how this change occurs in practice, particularly given the many recommendations historically on this issue that have not been enacted to date. For example, I cannot see how any significant reform like this can be led by a government department. I think we need to, which is usually the practice of how big reforms are done, I think we need very different governance and implementation models in the context of treaty and self-determination in order to make the shifts in Victoria that we are all working towards in many different ways, but we really want to have a sense of movement much more thoroughly. In our submissions, we call for long-term reform of both the child protection and criminal justice systems, underpinned by the principles of self-determination. Self-determination is a matter for First Nations communities, and the process of furthering self-determination in justice must be led by them. We wish to be supporters in that process, but we understand our role in that way. This includes embedding, in our view, First Nations people's law, cultural practices and other cultural interventions and supports, ensuring that the right to choose an ACO service can be realised, that we have strong and sustainable ACOs, and that they are best placed to participate in and make decisions about their communities and First Nations data governance and sovereignty. VLA very much appreciates its strong working relationships with Aboriginal community-controlled organisations, and I'd particularly call out VALS and JIRA. As recently as yesterday, the VALS board met with the VLA board, and this is a regular thing that we now have in place, which is really, I think, an excellent contribution to thinking about how we both could have common aspirations and what we need to contribute to in order for us to understand how we can best support the work of VALS. We need to consider different ways to get the change we are seeking. To reiterate, self-determination is absolutely the key. It is unlikely that a government department will be able to deliver and drive these reforms in the transformational way that is required. We need First Nations peoples involved in the design of these new systems and driving this system as it is designed, led and controlled by First Nations community. In short, this is the most, I think, important part of the work that you have been charged with doing in many respects. Finally, we also acknowledge our own deficiencies as VLA. We have significant work to do as an organisation in being part of building a better child protection and criminal justice systems. We are continually working on improving our own cultural safety, including increasing the number of First Nations staff we employ, the pathways we offer, mandatory cultural training for staff and practice standards for the many practitioners that we fund every single year, but we still have some way to go. So we're very pleased to answer any questions that you would have or the Council would have in relation to our broad submissions that we've provided. And once again, we thank you for this opportunity.
Thank you very much for those opening remarks. I propose to take you first to your child protection submissions.
Thank you.
I will observe, though, that in respect of the criminal justice system submissions, to which a covering letter dated the 21st of November 2022 is attached, in the first paragraph, the following observations are made. First Nations people experience far-reaching and intergenerational harms at the hands of the criminal justice system. In our practice, in every court across Victoria, we see these harms persist today, including disproportionate rates of remand and imprisonment and deaths in custody. It goes on in the second paragraph. These harms are a consequence of centuries of laws, policies, systems and structures that have entrenched systemic and structural racism and normalised the exclusion and disempowerment of First Nations people and denied their right to self-determination. Those observations are made with respect to the criminal justice system. Can those same observations be made with respect to the child protection system?
In my view, they can, and Joanna, I'm sure, would be pleased to talk about this a bit more thoroughly, but I think part of what I understand the work of Yoorrook is for us to hear stories and people's experiences, for someone like me to understand them as thoroughly as we can and to think about what changing and transformation looks like in that context. I think this does require us to look back quite thoroughly to understand the history, not only of this state but of Australia, and I feel I have some understanding, but I feel one of the fantastic things about Yoorrook is that it's continually presenting ways of understanding to us, and we see our job as being part of this understanding. And I think that though the people that we see, particularly in child protection systems, exhibit a lot of their own pain and their own complexities that relate to experiences that are intergenerational, that they continually see in different ways in their own contemporary experience, and therefore we cannot not have that sort of lens. But Joanna, did you want to add to that?
I wouldn't add much to that, but just I think to point out that in our submission, Michaela's lived experience statement really does sort of underscore that point. She was herself taken away from her mother by child protection as a child. She had ancestors who had been part of the stolen generation, and then she herself became involved in child protection as a mother.
Commissioners, the lived experience of Michaela is at Annexure 1 of the VLA submission. That might be a good point to start, Joanna, and ask whether you are able to give the Commissioners a bit more detail about that statement from Michaela.
Can't give you any more detail, I'm afraid. That was a part of a very thorough interview that she did with one of my colleagues, and I think she's really sort of set out her own experience, but also what she would really like to see Yoorrook come up with.
Sorry, not additional detail to that which is
right.
Set out in the annexure, but perhaps explain to the Commissioners the salient points from that from VLA's perspective.
Sure. Well, I think the first one obviously was the intergenerational experience. Secondly, I think the fear that she therefore felt because of that intergenerational experience, which caused her to respond understandably with great concern when the department became involved. Another aspect of it I think that's really worth noting is that she was in a family violence relationship. That's the massive driver into the child protection system, unfortunately. At one point, as her statement talks about, she kind of lost it after being really under pressure with the family violence. That led her to be in prison, which then made her relationship with the department even harder. She talks about some of her experiences in the system, but I think the context for Michaela being able to tell this story is that she's part of our advisory group for our independent family advocacy and support. And that is a representational advocacy model in which I think she felt that she was finally given a voice, and that was a voice that then was heard by child protection. I think this quote at the end I'd really sort of like to highlight to you, and she's really become an advocate, as a result of her own experience and then being involved with our service. I want my children to grow up with a sense of belonging. I want my children to grow up with their identity being known to them. 100% really open and honest, because I never had that as a child. Adults' decisions and adults' choices got in the way of my identity and my Aboriginality, and that's why I'm teaching my children now. And I think that flags, in a way, the really fundamental point that we need a self-determined system.
Thank you. Now, you are aware that last week the Victorian Premier Daniel Andrews made statements recorded in the press about the need for an overhaul of the child protection system.
Yes.
Can the VLA give a response to that statement by the Premier of expression of a need for dramatic change?
Well, I think we would say we welcome that, and it was very encouraging to hear the Premier talk about that. I think the key issue for us really is how that would be done and what are the steps taken in that. I think we'd also, our submission stands for the point really that we think there are some immediate things that could be done that should be attended to, as well as longer term issues. So the thought of standing up a whole new system and way of working will take time to do well, and I think we do sit with the position that we would like to see some things happen earlier than that, which are more immediate, as we've identified, but we would be fully supportive of that. And our submission gives some examples of the things we think that should be thought about. I've perhaps mentioned one in the opening statement, that it's a bit different, I think, than just having a department manage things. We really need a process which is, from the very beginning, starts with the self-determining and involves First Nations people in all the thinking around how this would look very, very thoroughly. So it's exciting, but it's a big piece, and we would want to be supportive of that.
No doubt it is a big piece of work. The Commissioners have heard evidence this week from the co-chair of the First Peoples Assembly of Victoria, Auntie Geraldine Atkinson, to the effect that the Assembly believed an overhaul could be conducted through mechanisms established through the treaty negotiation framework, with the Assembly working with the Aboriginal community-controlled organisations in the sector. And then yesterday we heard evidence from VALS, the Victorian Aboriginal Legal Service, calling for standalone Aboriginal child protection legislation. You've mentioned the need for Aboriginal people in Victoria to be self-determining in the creation of these new structures. Are those propositions from both the Assembly and from VALS consistent from your understanding of self-determined engagement in the child protection system?
Yes, I would say. I don't know, Joanna might want to add to this, but I think that's exactly the sort of thing we want to see, and that's why it's important to be talking and thinking about this, because it will require very different ways of working with government, I think, and clearly there are roles for different organisations. We leave those to First Nations people to think about what they might be, but yes, we support these reflections and suggestions and recommendations made by ACOs.
And I would just add, I think that the use of the word reform, however dramatic it is, and reform is great, but transformation is really what's needed. And I think, therefore, having a separate act is probably, it's hard to see any other way of doing it than having a separate piece of legislation.
In evidence yesterday, VALS expressed the view that really the existing Children, Youth and Families Act couldn't properly be reformed to accommodate the needs of Aboriginal peoples of Victoria, and there's a real need for standalone legislation. Is that a sentiment that VLA has any difficulty with?
No, not at all. I mean, it's a very, like many acts which are growing in size, they have often been constructed perhaps well in the beginning or not, but they've had lots of provisions and changes added to them. So I think in order to really achieve the aspiration and transformation we're talking about, a new act is necessary.
Thank you. Now, I just want to take you to some of the urgent measures that we've identified requiring immediate action. The first is restating the court's ability to make orders in the best interests of the child without the time limits on reunification. Now, we heard some evidence from VALS about this yesterday. Could you just explain to the court what you mean by...
Yes, I'll hand to my colleague Joanna. She's got
Sure. This is a provision that only came into the legislation in 2015, so it's relatively recent. It came in, we would say, with very little evidence to suggest that it would be in the best interests of children. it has led to more First Nations children being on third-party permanency orders, on care by secretary orders, and with the court having less oversight of child protection decisions. And so essentially the way it works is that there is a rigid 2-year time frame for reunification when a child goes into care, into out-of-home care, even where those are interim placements and there hasn't actually been a finding that there's a need for protection. And then at the end of that 2-year period, if a child can't return home and there isn't a permanent carer available, they end up in with parental responsibility being held by child protection. And so obviously this is an issue for all children, but it's particularly acute for First Nations children.
Can I ask a question about this? I have a growing understanding of this, not a perfect understanding, and I think Commissioner Hunter will close to a perfect understanding. My understanding is that the significance of the 2-year time limit is that after that the child is permanently placed with a non-Aboriginal family. Is that the bottom line?
It wouldn't necessarily be a non-Aboriginal family if there was a non-Aboriginal family available, but it just... One of the challenges with this sort of artificial time frame is that it's actually very difficult to get families the services that they need to enable them to be reunified with their children, or their children to be reunified with them. So, and even the 2-year time frame actually only applies if you can show at 12 months that there's a compelling case that the child will be reunified. And if you've got someone who's struggling with drug addiction or mental health issues or homelessness, family violence, those things take a long time to address. And as I said, the key thing really is the absence of services during that period.
So if there's a 2-year window within which reunification is to be achieved, what happens after the 2 years expires with respect to that prospect? Can reunification be achieved after 2 years, or is it ended?
It is still theoretically possible. I mean, some ACOs, for example, have been able to get children reunified with parents from a care by secretary order. So it can happen, but it makes it very, very much harder.
And I think we established yesterday that the permanency does not necessarily mean that there is a permanent placement, and that child doesn't necessarily go into a permanent placement, even though that's the reason given for putting them on the order.
That's exactly right. There isn't data to suggest that they are actually in stable placements. And in fact, Commissioners might be aware of a recent report by Sarah Wise and Judy Cashmore, which is a comparative analysis of third-party permanency arrangements. And Sarah Wise is one of the researchers on the department's permanency amendments longitudinal study, which has not been released yet. But their findings in that report were, yes, permanency arrangements that were not matched by the evidence on the ground. In particular, there's no research on outcomes for children, and we're now 7 years into the amendments in Victoria. There's little monitoring of whether those placements are actually stable and emotionally secure for children, and whether carers may be facing significant challenges and they no longer get support if they have a permanency order placing the child with them.
Did you say that report's been written?
Yes,
Sarah Wise, and it's, yep.
Yes, that's available. It was in September 2022, and it's called a comparative analysis of third-party permanency arrangements.
Thank you. And the situation could be alleviated somewhat if there were sufficient resources provided to families to support them in terms of preparing for reunification?
It could be, but I would say that's not the solution. That actually, in very complex situations, when you're thinking about, intergenerational trauma, having rigid timelines, and particularly removing the oversight and discretion of the court, I think is particularly concerning. Services would make it less bad, but they're not a solution in themselves.
In their submissions, the VALs have suggested a replacement care and protection order, as opposed to the suite of orders that now exists. Have you had the opportunity to consider that particular form of amendment that they're suggesting?
We have, and it seems sensible. I mean, we haven't looked at it in the level of detail, and obviously they've basically drafted the provision, which is great, and they've done that very thoroughly. But the idea of basically having one type of order with a range of different conditions, I mean, for simplicity, it's a good idea, but also it addresses these issues about the reunification time frame. So, yes, broadly supportive, but haven't been into the detail.
But the VAL's draft care and protection orders allow for ongoing monitoring by the court of the circumstances of the placement of children and the orders in relation to them. And that is a good thing from VLA's perspective?
Yes.
Would that in effect mean that the balance to be struck between permanency and reunification, where that's an issue, is one for the court to make on an ongoing basis?
Yes, yes. And that was the situation, not as neatly legislated as Val's proposal, but that was the situation before the permanency amendments in 2015.
Now, another matter of urgency from the VLA submission is ensuring compliance with the legislation by the department. One of the matters which is highlighted in the written submissions is the non-compliance, if I can put it that way, with the need for cultural plans. Could you just speak to the commissioners about that?
Sure. We've seen instances where cases are very close to a final hearing, 18 months in even, and a cultural plan has not been done. And I think there are findings, I'm not going to be able to reel them off, but I think the Commission for Children and Young People has made some findings about the rate at which cultural plans are not done at all, or where there's a significant delay in them being done.
Thank you. There's also a recommendation in the VLA submission for a greater investment in the Aboriginal community-controlled organisations for the development of cultural plans and oversight of their implementation.
Yes.
If you could just speak a little as to the importance of that involvement by the community orgs in developing those plans, that would be helpful.
Well, I think it's essential, and there have been, there are resourcing issues for those organisations that have meant that sometimes there are delays in getting those cultural plans done. Sometimes the delay is clearly from the department, but where in other instances resourcing has limited impacted timeframes, which has meant children being longer in out-of-home care. So there is a big resourcing gap, and I think particularly in addition to the one around the specific development of cultural plans, some of the other principles that are supposed to apply for First Nations children, including having members of the Aboriginal community or senior people from other parts of the Aboriginal community involved in decision-making, those are also not happening consistently. And that's partly an issue of the resourcing of ACOs to do that work.
Thank you. And going now from the development of the plans to supports for families for reunification, the VLA submission speaks of intensive supports for families to achieve reunification. In particular, you mentioned the importance of the VACA program,
Google. Yep.
Can you just speak about your observations about how, the utility of that program and how it's working?
Sure. Noogle is VACA's version of the Section 18 provisions, which basically mean that once an order is made, other than an interim accommodation order, an Aboriginal organisation can exercise those powers. I'm sorry, I just got distracted then. What was the rest of your question?
As to VLA's observations as to the importance and value of the Noogle program.
I mean, I think the stats speak for themselves. I'd like to be able to tell you what they are, but I think it's probably about 4 times the rate of reunification for a child who's being managed by Noogle rather than child protection. So just purely on that basis, it's very successful.
And the VLA supports a more broad adoption rollout of that program?
Absolutely. And I mean, I think clearly though, and again, going back to the self-determination point, there may be Aboriginal organisations who don't want to take on that particular power because still, they're still having to operate within the legislation, which is problematic in itself and needs an overhaul. But in the short term, if there were other Aboriginal organisations, I think currently it's only VACA and BADAC in Bendigo who are fully authorised to exercise those powers, and some other agencies have come on board, I think, but are not yet. It's more in a pilot phase. But if there are more Aboriginal agencies who would be willing to take on that those Section 18 powers, I think that would be very useful given what Noogle has shown us.
Thank you. As a further urgent recommendation, the VLA submission calls for the development of a statewide specialist children's court. This is a recommendation that VLA has been making for some time.
Yes.
Could you just speak to it for a moment, including your VLA's observations in respect of the Murrum Nala Gumbu court?
Thank you. As commissioners would be aware, outside metropolitan Melbourne, the Children's Court is basically held in the Magistrates Court, and a magistrate who has a general range of responsibilities just puts a different hat on and is then the Children's Court. What we see both in terms of decision-making, sometimes delays in decision-making because a particular magistrate may feel they don't have the expertise really to make that decision. And I think, I'm not sure if this is more worrying or just the same, but sometimes just actually getting time for things as urgent as emergency care applications in a magistrate's court, because there's not a standalone registry or specialist registrars, those matters can be delayed in those courts. And there is a lot of inconsistency in practice between the Children's Court sitting in magistrates' courts and the Children's Court in Melbourne. So the president of the Children's Court technically can make practice directions that apply in the regional courts, but they're not always followed, probably not even often followed.
What about the sitting arrangements? Do the hearings occur in court?
So I think it's a really important thing to think of the physical surrounding too. And when our board and Joanna and I were there in it as well, we sat around the table where these matters are heard. The magistrate is not raised. She in this instance sits around the table as well. We watched the method and the dialogue with how people are engaged with, and there is a big emphasis on hearing from people and making sure that there is an understanding of what's occurring. So time is given for this sort of thing, and it draws on the comments that other parts of systems would make. So it's a supportive environment, and there is, I think, it's very impressive in terms of how that. Even though it's a decision-making process and it's nerve-wracking, I'm sure, there is essentially an element of support and collaboration in there in terms of how this work is done. Look, I'm very familiar with Koori Court's therapeutic jurisprudence, problem-solving courts, but this is, I think, a really excellent example.
Describing Murrum Nala Gumbu.
Yes, exactly. Yes, I am. And can I say, it's also very cheap. I asked how much would it be to replicate this across courts in Victoria, and I was, I can't recall those figures, but I remember thinking that is not much money. And because often it's about the orientation and having the right people and having the right processes in place. and just ensuring that people are treated with dignity and respect. And I know that it's important for all our courts, but in this instance, this ability to engage and interact, to ask questions if you don't understand, it is just so important and essential. So for us, this is a bit of a no-brainer that this is something which is socialised much more thoroughly across Victoria.
Can I ask where the court sits in the regions? Does it sit in the ordinary, when a magistrate in the region
Yes.
is exercising children's court power, where does he or she sit?
Yes, just in any
in an
courtroom of the building.
This Marinala feels a bit like this. It is also there's I'll probably refer them incorrectly, but the what's on a table and what's in the middle of the table, and there's paintings, cultural objects, statements and things that are important are very much part of it, and that is a terrific way to make people feel at the very outset that there's some understanding here of culture and family and community, and there's writings on the wall. So often there's a particular room that's designated for this purpose. I think that's a minimum, really, in my view, but it is pretty impressive to sit and watch, and we did hear several matters determined and even explaining who was there and why we were there. It was so respectful. It was so respectful that I think it's a great model.
Thank you, Commissioner. Without delving into emotions,
yes,
the way in which you've responded to the Commissioner's questions about the operation of the Nala Gumbu process, can I suggest your experience was one where you felt, why can't we do it this way?
Yes, exactly. And
this is the way it should be done.
Yes, that's right. And I don't mind a bit of emotion, actually, because it is an emotional thing, in my view, to watch young Aboriginal children and their families be truly listened to when they talk of their experiences and what they've been trying to do to improve their circumstances. And so I think, there's a place for that appropriately. We're in a court, so I know that. I'm a lawyer. I understand that completely. But I think that you have to look to see, and I think the people in this court looked to see. They were looking to see what was going on for this young person, for this family, for this mother. It was for the other relatives that were there. It was really very pleasing to see, to be honest.
Thank you. And if we can move on to the way in which the department works now, perhaps in contrast, your submissions identified that another urgent reform is the separation of the core functions of childcare. And in particular, you point to the separation of the investigation function from the support function. Can you just explain the importance of that, perhaps?
Yes, I mean, I'd like, perhaps Joanna can do that. That's very important. But I'd also like to say that we don't want to be. Our purpose is not to be critical of the department. It's just to say it's not working, and there are many good people who are in there that we know that we work with, and I think that's important to say, and who want to work well and effectively. Our comment is really about how it can be done better. Really, generally speaking, and so this is where this point about the separation of protection and concern comes about, I think.
So the discussion that we're having is one at a systems level.
Systems level, exactly.
At a systems level, your submissions seem to suggest that there are real problems in having the same department, and in fact sometimes the same people doing the investigative function as well as the support function.
Completely.
Yeah, absolutely. It creates a massive mistrust between the person being brought into the child protection system, the parent, the children, to have, actually probably would be the same worker that's supposed to be tasked with providing support, finding services to assist this family to stay together, then also kind of having the available option of a formal investigation and taking the family to court. But yeah, as Louise said, that's built into the system. That's not about the way individual child protection practitioners take up the role.
No. And indeed, in submissions, oral submissions yesterday, we had some discussion from Val's about the need to separate out the litigation function from the other functions. And I see you nodding your head. Are you in agreement with that proposition? And
Yes, and I think this is another sort of recommendation that has been made at least twice and not adopted.
And for all the reasons in relation to a separation of decision making regarding the litigious functions from the support functions.
Yes.
Now, speaking of support functions, in your submissions you refer to the IFAS program. Commissioners, I'm not sure whether in your material you have this document. I might hand it up.
Very short summary.
Yeah.
Very short summary. If you could describe the IFAS program for the Commissioners, please.
Yes. So independent family advocacy and support, and the focus is, as it sounds, on support, but the type of advocacy is we think reasonably is quite rare, and that is that in the child protection system it's rare, and that is representational advocacy. So these are non-lawyers, and that often creates an easier space with the department that they are non-lawyers, and they are advocating on behalf of the client. They're representing directly that client's wishes, so they're not. It's not their responsibility to look into what's in the best interests of the child, but rather they are a voice for the client. That being said, of course, they can test what the client's thinking and saying about best interests, so that they will know what is a likely response from the department and how to manage that. That was evaluated last year, and it was a really favourable evaluation. Many qualitative things to say about parents' experience of IFAS, but key, I suppose, is the percentage of families diverted from court, which is 20%. So avoiding that very uncomfortable and difficult process. And we assisted during, I think it was during the period of the evaluation, we assisted around 200 people, and 25% of whom were Aboriginal. And we did that all by having a co-located worker with both the Aboriginal Corporation in Bendigo and in Ballarat. And I mean, I think what we're bringing to you, I think, is not legal aid needs to be funded to do this work, but just this is a very successful model of representational advocacy, and currently it's only available in Northern Metro, Bendigo and Ballarat. Again, it's also very cheap.
And looking at page 2 of the evaluation, the observation made that the program saves the Victorian government $2.66 for every dollar invested.
That's right.
What was the organisation in Bendigo?
Bendigo District Aboriginal Corporation.
Yeah, thank you.
And the organisation which undertook the evaluation on behalf of...
It was RMIT.
RMIT.
I will tender that summary in due course, Commissioners. Finally, I want to take you to the point in your submissions relating to criminalisation of children in residential care. Just, I might ask you to speak as to the prevalence of the issue.
Yep. I'm not sure if I have that off the top of my head.
Not in strict terms, but
Sure.
In general terms.
General prevalence.
Yeah. It's far too common, and police are called for things as mild as throwing a sponge, taking food from a kitchen, and you know that is a very obvious funnel into the criminal justice system. So, we obviously know that there's, that there's a lot of correlation between children being in child protection and children being in the youth justice system. This is a very direct connection. This is children who are in child protection, directly being ending up in youth justice because of the way they are responded to in residential care.
And as your submissions point out, there was advocacy in place for a considerable period to develop and have adopted the framework for reduction of criminalisation of children in residential care, which was supported by the VLA. And that framework has been in place now for some period?
Nearly 3 years.
And is there any observation that you can make as to the way in which it's being implemented or observed?
As far as I know, it isn't really being implemented. The key things that we're calling for is real clarity about what that will mean for individual children. So it's a high-level document, the framework, and it needs an implementation plan and then appropriate measures. And that work lapsed for at least a couple of years and is now starting to move, but we're just concerned that it will, that there'll be another lengthy delay before it's actually practically implemented.
We heard evidence yesterday again from Val's representatives that the framework, their observation was that police officers involved in matters involving children in residential care were often unaware of the framework. Does that come as a surprise to you?
No.
And that points to the lack of an appropriate mechanism to ensure that the framework is actually brought into full operational use?
Yes.
Thank you. They're the questions I have with respect to the child protection submissions. Are there any matters of which you would like to expand on at all, other than as in your written submissions, which is of importance?
I don't think so. I think the other issues that we've raised are, are very clearly laid out in our submission, and the fundamental thing. We've been talking about the urgent things and the relatively easy things that can be done right now, but just going back to where we started and where Louise started, fundamentally this system needs to be rethought from the ground up for First Nations children.
Ms McAvoy, can I just...
Yes, Commissioners. If there are any questions in relation to this child protection area before we move to criminal justice, it would be convenient to take those now.
Yeah, we just heard about the framework yesterday from Val. It's about the framework to reduce criminalisation of young people in residential care. And you sort of mentioned a few incidents. Would it be fair to say what a child may do at home, the police would not be called?
That's exactly right.
But in a residential setting, for even...
Relatively minor.
Yes.
Yeah. So as the carer or guardian with authority over this child, for a sponge throwing could be turned into a criminal charge.
Yes.
Is that correct?
Yes.
Thank you. Just wanted to clarify.
I just wanted a little bit further on that one. It seems remarkable that despite the framework being in place, this is still happening in residential care, which you would think would be more aware of the sort of the guidelines and protocols and principles than perhaps a foster carer or a kinship carer. So can you offer me any illumination as to why it's...
I think it might be something I'll need to take on notice, but my sense would be that it is literally because the framework hasn't been implemented. It's essentially at the moment an agreement between DFFH, Justice, VicPol, and I think that might be it. But that, as far as I know, that just hasn't been rolled out to people actually doing the work because it's a framework. It's not a this is what you need to do if this happens. It's a kind of overarching document.
Does that point, just as a follow-up, with the uselessness, but the lack of actually efficacy of frameworks without measurement and of success and accountability built into them,
Yeah,
and
absolutely.
that we see a lot of frameworks without those in this area.
Yes,
I think that's so true, and I think you always want to know what the implementation steps are, and you've got to have robust processes for understanding if there's been accountability in relation to those. Can I say there's also, I think, a very significant cultural piece that sits around this as well, and how I would see that would be in a framework such as this one. Those organisations should come together regularly and talk about how they're going and what they're learning and what differences they'd like to make to improve the experiences or the responses for young First Nations people. So it's sort of, I think it's about how do we continuously appraise and get better rather than just saying, well, here's something, yes, tick, we all like that. It's got to be much more held in mind in terms of the work that's being done by people, and that's a cultural piece. That's got to be learning within organisations about what is proper, what is respectful, where are we trying to get here, all of those sorts of issues.
But as Aboriginal people, we're well used to seeing framework after framework after framework, and I just wondered, does this sort of feel like doing a framework is enough, and then you sort of move on? That's okay, we've dealt with that, we've done a framework.
I mean, my own view is maybe that's not intended, but that's often, I think, what happens, and that's why the implementation piece there has to be monitoring, and there has to be consideration of why things aren't moving if they're not moving. And I wouldn't want to say that that's intended at the outset, but you would have to say that yes, there's not much point in a framework if it's not implemented properly. Yep.
Can I just add to that? Commissioner Walter, would you agree that the most vulnerable of our children in out-of-home care end up in residential care?
Yes. Yes.
Yeah. I do have one last question. I was going to bring it up with Val yesterday, but I forgot. With the permanency or permanent care orders and with the cultural support plans now in place, do you see the cultural support plans being part of assistance to getting kids home? Or because of, well, we've heard a lot over the last week around, I guess, the lack of appliance or the lack of depth of cultural support plans. So I'm just wondering if that would add. And just from my experience, there's always been a culture versus attachment issue at permanent care. And so I was wondering if that bringing cultural support plan in would sort of help settle that argument in court.
Sorry, could you explain what you mean by the cultural safety versus attachment?
So if a child's been in care for 2 years,
yes, okay.
The stability, so the attachment of the child to the carer, whoever that may be, to going home, and it becomes an argument about culture versus attachment.
I see. Yes, I do think cultural safety plans could really assist with that.
I've got a question about human rights accountability, and it's a little bit arising from what Commissioner Walter's question about failure to implement frameworks. With respect to the human rights in the Charter, there have been a number of test cases across a range of subject areas in the past 15 years. Prisons, mental health in several respects, working with children, 7 or 8 areas. There have been test cases where the interaction between decision-making affecting the human rights of people and the Charter have been worked through. I don't think there's been any test case like that in the child protection area.
I think that's
Not
right.
that I'm aware of.
Yeah.
No. There's one in relation to the procedures of the Children's Court, and that's about all that I'm aware of, which I find really surprising because of the really serious human rights implications of child protection decisions. This is not meant as a criticism, but rather just as an observation that one means of human rights accountability, that is judicial supervision, doesn't seem to have had any influence or any relevance, can I put it that way, to the operation of the system.
I think, I make a more general observation, Commissioner, and I think in closed systems, in systems that are more closed, less permeable, it's often less likely that you do see these matters taken up within a charter framework or a human rights framework or an UNDRIP framework. And I think we know this because closed systems are, they're not permeable in quite the same way. And I suppose I'm thinking of, prisons, I'm thinking of, separate care arrangements. I think Dan and I have had discussions about this at different times, but that the closed systems, I'm thinking of, what happens for sometimes people with disabilities in their living arrangements and what they experience as part of that. And so as a civil society, I think we have to have particular attention to closed sort of environments, and that's why this is a good example in the child protection space, because it is hard to get a sense sometimes of what is happening and what rights may or may not be being afforded their proper place.
Could I just also come back to Commissioner Hunter's question, and just in response to the cultural plans? Absolutely yes for cultural plans, but they need to be robust, they need to be well thought through, and they certainly need to have and be informed by the mob, not written by non-Indigenous people and put in front of us and used as a mechanism that says, well, we've got a cultural plan and we'll tick it off. And look, we've seen this in parts of the education system where learning plans for Aboriginal kids were put forward, and some of those worked very well and some of those were just a tick and flick exercise for schools to be able to, with staff, then say, well, we'll do X, Y and Z and, we'll see where we get to with at the end of the year or the term. But cultural plans, absolutely. The self-determination side to that has to include, must be, our mob sitting at the table, being party to that, writing those and ensuring that they're delivered in a way that meets the need of that child and that family in a culturally appropriate way. To end on that, Commissioner Bell, you also, your comments in regards to oversighting things and that, certainly VLA has had a robust conversation, and we put forward in our submission around a social justice commissioner to oversight some things. Yep. But again, it would need to have teeth, would need to have the ability to bring things to account in a way that affords our mob, with knowing that things, checks and balances are there, and that we know that we're going to be able to monitor and get outcomes from things and keep things where, as we've talked about, self-determined in the principles of that sort of thing.
Can I just ask, in that case of cultural support plans, and I think as you said before, the person who's going to litigate somebody shouldn't really be the one trying to, it just doesn't work. So the department are in charge of writing those plans, am I correct?
That's right, yep.
Okay, so how would that work in engaging the mob in the same respect as the people who are litigating them? How?
I think that there's been conversations around different ways of doing business and different models. And look, I think certainly some of the things that VLA have been going through recently in terms of lived experience groups and going back and providing mechanisms that are open and transparent and bringing people to the table, and you can actually see what's going on. I mean, that scenario that you speak to there, Commissioner Hunter, it's like having police investigate police. It just doesn't work.
Thank you. Thank you.
Thank you, Commissioners. I now propose to ask some questions in relation to the VLA criminal justice missions. I might commence by making the very trite observation that in Victoria, as in other places in Australia, criminal justice is regularly reported upon. And if we turn to Appendix B of the VLA submissions, see key submissions which have been made in the last 2 to 3 years, and then other relevant submissions in relation to the criminal justice sector and relevant public reports on the following page, all within the last few years. So it's not as though the matters that are coming before this Yoorrook Justice Commission are not ones that have been brought to the government's attention in the past. Is that correct?
Yes, and I'll ask Dan to talk a bit more about this in terms of his leadership of the criminal law space for VLA. But it is our obligation under our legislation to advise attorneys, federal and state and ministers of what we are seeing on the ground through our work. And there are often calls for submissions. We see that as a particular responsibility we have to be bringing attention to things that we think are problematic in systems. And it is, and Dan will probably have more stats than I have, but sometimes I feel we're asking for things we've been asking for a long time. And I think, part of that really is trying to understand whether there's an appetite for doing things and how you actually get movement on some of these issues. But many of these submissions, for example, would cover not dissimilar issues to what we're raising here today.
So I might make the observation that in March this year, the Legal and Social Justice Issues Committee of the Victorian Legislative Council produced a voluminous report.
Yes.
Some 900 pages into Victoria's criminal justice system. It was titled, I think the inquiry was entitled An Inquiry into Victoria's Criminal Justice System, and that report included some 100 recommendations and 73 findings. The VLA made a submission to that, the Legislative Council, and some of your officers gave evidence.
Yes, so Dan can talk to this. Dan and I gave evidence. And,
that's right, yes.
Yes.
And so I'm just going to hold up the document, which is your submission from September 2021.
Yes.
Will be tendered in evidence. Since that report's been handed down in March this year, has there been a positive government response and any action upon the recommendations in that report?
There hasn't been significant action on the recommendations in the report, and I think I'm right in saying no formal government response has been tabled yet.
So,
I was just going to say, if you look at the 5 urgent priorities that we suggest for reform in the criminal justice system, each of those is covered in that report in some way and in other reports that have been produced over the years.
and it's clear that some of those recommendations or findings that the Legislative Council has made in Victoria in the report that came out in March this year have their origins in the Royal Commission into Aboriginal Deaths in Custody report from 1992.
That's right. So if I took the example of public intoxication, we had a look back at decriminalisation of public intoxication to see how long ago and how often it had been recommended. And I think it was first recommended by a Law Reform Commission report in Victoria in 1989, then in 1989 and 91 in the Royal Commission into Aboriginal Deaths in Custody. So I think over the years there's been a number of other recommendations. Of course, the coronial inquest into the death of Yoorrook woman Auntie Tanya Day, and we know that that reform has been legislated but not yet commenced. And so I think our research indicated it's been 33 years and there have been 7 different commissions and reports that have recommended its decriminalisation, yet today we're still waiting for that reform to take effect.
And can I just ask Dan, most jurisdictions around Australia have removed public drunkenness from the statute books.
Most have, yes.
Yeah.
Now, moving along, the VLA submission to this inquiry identifies 6 foundational reforms for a fair criminal justice system as regards Aboriginal people. But the first of those foundational reforms is that a self-determined criminal justice system be built for First Nations people. In their submissions, VALS has called for a justice treaty. If by that we assume that they're referring to a justice system which is enacted as a result of negotiations and gives full voice to the principles of self-determination, is that the sort of self-determined criminal justice system that the VLA supports and is referring to?
Yes.
In Appendix A to your criminal justice submissions, you refer to a number of facets which are reflective of meaningful self-determination. So the first is building First Nations justice into the system. Can you just address the commissioners as to what is meant by that particular term?
Yeah, I think if I start off on that, I think we've talked about the need to have a voice, and so even today having a voice at this hearing here and being able to speak to these sorts of things, being able to put forward initiatives that are driven by us, the mob, in that space, and you've heard about a couple of initiatives this morning that are working very well, that have been again voiced and put forward by the mob in regards to fairer outcomes. So I think in terms of the self-determination question on that, it goes to the heart of us as community and the range of other stakeholders that are in the space, such as our peak bodies, and we've talked about some of those here today, such as VACA, such as VALS, such as JIRA, whether it be VAI, Victorian Aboriginal Education Association, the Aboriginal Justice Caucus, collectively being part of the solution and putting forward, I think, the practical applications to that side of it. And so VLA, in terms of, stepping up to and understanding what self-determination means for them in terms of delivering a service to Aboriginal people across the state. Certainly you've heard bits of that here today as well in terms of lived experience groups, going back to Aboriginal clients and actually sitting with them and getting to understand what worked well in a service delivery perspective, what needs to change, understanding what cultural competence or service standards, practice standards mean in that space. So I think there's a range of things in the delivery of what does self-determination look like in regards to that. But that's sort of my take on it. Dan?
Well, there are a couple of other issues mentioned in the written submissions, one of which is data governance and sovereignty.
Yes.
And so the importance of control of information,
Yes.
and not just control, access to it.
Yes.
We note that the VLA has supported VAL's submissions in that regard, and also the support for this submission around an Aboriginal Social Justice Commissioner, and Lauren spoke about that
Previously.
a few moments ago.
Yes.
And that Social Justice Commissioner could have a very important role in the accountability and
Yes.
monitoring
Yes.
of the system. The second foundational aspect which is referred to in the submissions, is the identification and addressing of systemic racism and bias in the criminal justice system. The submissions note the findings in the Our Youth, Our Way report, and then talks about the way in which the system itself might change to reduce the effect or prevalence of systemic racism, including training of lawyers. That's correct?
Yes.
And Commissioners, on request from Council assisting, the VLA has produced a document of further background information about VLA, and there was some discussion of the content of this document in the opening remarks, but it's important to note that that the VLA has mandatory e-learning modules for its staff, which include other ways of knowing Aboriginal culture, working inclusively with Aboriginal and Torres Strait Island clients, diversity in the workplace, unconscious bias in the workplace. And so there is a range of mandatory training for their legal staff, or is it all staff?
All staff.
All staff
actually,
internally.
All staff, yes.
So is that, I mean, it's difficult for VLA to talk about the way in which other organisations ought to go about their business, but is it reasonable to expect all organisations that are having dealings with the Aboriginal community to have a high level of internal training to develop their understanding of their own biases and
I would say yes, it is. And I think at VLA, and I'm sure Dan will add to this, we have a strong staff network, so a First Nations staff network, and we see ourselves as very much accountable to them in terms of addressing the things that they would raise with me and with other executives regularly about how we can improve our practice. And that's part of the continuous improvement. You know, you want that engagement, and you want you don't want the burden to be totally on their shoulders. You want to be learning more about yourself so that you're really building organisations which can be proud of their cultural competency, understand the support of First Nations organisations, and be contributing to overall reform in that way. But Dan can probably talk a bit more if you want about particular initiatives we've taken in that space.
Yes, sure. So, we have a role very much in working with our own staff, and some of those foundational trainings are important that you've mentioned, but also very specific things like making sure we're, when a First Nations person is on remand, making sure we're doing bail applications and strong bail applications, and we've done a lot of work with our own staff in that, making sure we're making full use of the law that can help get our clients bail. But then beyond looking at our own staff, you are right, there is a big challenge across the whole profession. And the whole profession, legal profession, starts from a pretty low point where law schools and other formal education doesn't equip people to represent Aboriginal clients as well as they should.
Can I just ask a question on that? Yes. So legal training is quite lengthy.
Yes.
Why do you think universities are still not providing adequate education and training for people who are then going to be released out into the community and to actually work with Aboriginal people?
It's a big question that others will answer better than us, but I would say generally the legal training you get doesn't equip you well to be a legal aid lawyer. It's a very broad degree aimed at corporate lawyers and all other sorts. I know for myself, when I came out of law school and started dealing with marginalised clients, I was not at all equipped for that. And I think we haven't generally around the country seen the number of First Nations legal academics and others involved in the education system that we'd like.
Commissioner, I can indicate that we will be receiving evidence from Dr. Eddie Cabillo, the Associate Dean at Melbourne Law School, this afternoon, and his evidence goes to this point, and he will be in a good position to speak about that matter.
Thank you, Councillor.
Could I also just add a response to that, Commissioner? I mean, if it was me, I'd be mandating this stuff. But I don't get to say that. I mean, I'm just one person, nobody in the scheme of things. but it seems a no-brainer to me. I mean, there's things that we mandate around training requirements and skill levels and competency standards, you know. And, you look at the construction industry, for example, there's some things, bits of tools or machinery you can't drive unless you get a ticket and you can demonstrate that. Now, we've been talking about this, when I say we, I'm generally speaking about the mob in Victoria. We've been talking about these things for I don't know how long. Education's one of those, about how can a teacher in a classroom teach Aboriginal children without understanding some of the things we've sort of talked about here. And so to me, it seems to be a no-brainer in this space, and hence why I suppose the submission talks to things around practice standards and us, VLA, doing some internal work around that and starting to see how we can drive some of that sort of change in that way. But in terms of the universities, I am bamboozled as to why it's just not mandated.
I mean, I clearly, Eddie Capillo, is fantastic to be talking about these sorts of things. I do wonder, though, to take an emotional standpoint again, whether there is a lack of confidence and almost a bit of fear sometimes in the sort of learning that's provided. I do think that in universities they're places of inquiry, but I suppose there are more and more market mechanisms in place now about people studying for purposes for their career, and that's fine, and for the remuneration that will follow from that. And I do think that there perhaps isn't enough consciousness about the experiences or knowledge about the experiences of people who are particularly disadvantaged. And I suppose I'm talking not just about First Nations people, I'm talking generally. There is not an easy way sometimes for people who are senior in education systems to understand, put yourself in the shoes of the other and imagine what the experience would be like, and therefore tailor training that is going to assist people. I think it's quite a complicated thing, and it requires internal knowledge about your own beliefs and thinking, as well as substantive knowledge, and the coming together of those two, I think, is quite hard.
It's not a new issue, is it?
No, no.
But it is an issue that is gathering momentum, and Dr. Capillo will be able to speak in some detail about this particular issue.
Thank you.
I do ask, though, whether VLA has any requirement of its third-party providers. VLA briefs out to firms to provide legal services.
Yep.
And does VLA have in place any mechanisms to ensure that those agencies have sufficient cultural awareness or competency?
Do you want, or one of you can speak on that?
So we do have practice standards. That's the way that we say, what we require of private lawyers who undertake legal aid work, which is a large share of it. There's some reference to cultural awareness in those practice standards, but it's not very well developed. And a significant focus of our work now, including with Dr. Capillo, is to strengthen those practice standards. And as training and other mechanisms are developed, the part that legal aid can own is to mandate those for people who are doing legal aid work. And that's something that still requires a lot of work, I would say.
Thank you.
Can I just add to that, though? But I think that there is an opportunity in this space too to bring in certainly the ACOs, the Aboriginal organisations, such as VELS and JIRA, to be part of the respondent in terms of delivery of training or oversighting training, or being part of the group that has some oversight of that sort of stuff in the context of what we were just talking about.
Thank you. That's an important point. The submissions also refer to the need for greater levels of understanding within the other sectors of the other parts of the justice sector, including police, judicial officers, parole decision makers, corrections and court staff. And so is it fair to say that there are some things happening in some places, but there's no coordinated or overall structured?
I think that's right. I think there's a much greater awareness of this issue than I would even say 4 or 5 years ago. So I think there is, activity, and it is good that we have a judicial commission in Victoria, and that you can make complaints to that judicial commission about the behaviour, say, of court staff or judicial officers, and Legal Aid Victoria regularly does that if it has evidence of what we would say is inappropriate behaviour by judicial officers or even other staff, in raising that with heads of jurisdiction. And also, I think, we have ourselves just launched an anonymous reporting tool at VLA, and that's because we know that many of our staff, for example, won't report perhaps the racist behaviour that they've been confronted with as a worker in a setting, and they might tell us about it after the event. We really want to be very proactive in addressing the experiences of our staff as well as the experiences of clients, because many of our staff are people of colour, and as I've indicated, the numbers of First Nations people within that. And, it's not uncommon, and once again, Dan can talk to this, but some of our younger lawyers whose appearance might be particularly, colourful in some way, might be seen as either the translator, the client in a matter, but not the lawyer, and it is a very obvious bias that exists in understanding what role people are playing. And if they are a person of colour or a First Nations person, it is not uncommon for them to be seen as not playing the lawyer role, for example, which tells you something about the way the system constructs the players and the institutions within it.
And you'd agree that there has been work done in creating those mechanisms in relation to bullying and gender bias in recent years in the legal profession?
Yes, still a long way to go, though, I would have to say, and that's why we like the anonymous reporting tool, because we can use that information where people don't want to disclose because they worry about their careers or their future or whatever it is. We can use that information to look at trends, and we can take that information up with whoever we need to in our own systems or in systems in which we work, whether that be courts or hospitals or wherever it is, in order to improve practice in those areas. Did you want to give one or two examples, recent ones, or are they too particular?
We could be a bit particular.
Yeah, okay. But it's not irregular that we see these things happening.
No, but I mean, the failings in the system are still quite present. And
I think so, yes.
But evidence yesterday morning, indeed, from a solicitor to the effect that a magistrate told her client that he wouldn't be able to use the Indigenous or the race card on the next bail application.
Yes.
The Indigenous card. In your submissions in relation to identifying and addressing systemic racism and bias in the criminal justice system, you also talk about criminal justice system laws and suggest that all legislation should explicitly recognise the primacy of self-determination. That's correct?
Yes.
You also identify the need for culturally safe court services, the culturally appropriate judicial decision-making, and make the observations that it should be supported, including through individualised and informed sentencing options, restorative justice processes, and the use of Aboriginal community justice reports. You've had some experience with the Aboriginal community justice reports?
Yes, it's a relatively new project, obviously, but we've had some experience, yes.
It's still in a early phase?
Pilot, yes, but certainly in the case that I've seen, it was incredibly valuable in making the connection between the person's background generally and their specific experience of colonisation or dispossession or removal and the particular offending, but also in demonstrating to the court in a way that a lawyer is never really going to be able to do in taking instructions, how cultural connection is so important in whatever the sentencing outcome might be, and in the process of rehabilitation or however you'd like to describe it. So yes, in our relatively small experience, it's a tremendously valuable resource that we'd like to see made more available.
And that's that inability of the lawyer to get to the particular facts or issues that might be brought to the attention of the judicial officer, is that an observation that the Aboriginal community organisation with the right skills can collect that information from the individual, or is it some other observation?
Yes, it's both about skills and it's about, realistically, in a very busy criminal practice, also about time.
The other observation in relation to systemic racism is the corrections and transition services, so that the submission is that there are culturally appropriate supports in custody for inmates, and you refer to your submission to the Cultural Review of Corrections Victoria, and that includes transition out of incarceration as well.
Yes.
The third area that you address in your submissions in relation to the foundational aspects of a self-determined system is addressing the failures in intersecting systems that create and perpetuate disadvantage. Is it possible just to speak to that generally to give the commissioners a flavour of what's intended?
Yeah, sure.
Sure. I mean, I think we've probably spoken quite a bit today already about a great example of an intersecting system, which is the child protection system, and how if that system is failing, people get drawn into the criminal justice system who shouldn't be there. But one could make similar observations about the mental health system, the education system, housing. So if all these systems are not functioning to support people properly, providing culturally controlled or culturally safe support, people then end up, because of the failings in those systems, engaging in the criminal justice system. And that's something that we see in courts all the time.
So those matters which are in other sectors often talked about as the social determinants of disadvantage or that type of indicators are the very matters that are impacting on the people's interaction with the criminal justice system.
That's right.
One of the other areas you speak to in your submissions, though, is victim support. Can you just explain the need in this area?
Yes, there's a lot of evidence now about the importance of treating victims differently as actors in the criminal justice system, providing them with early support. And it's well established, and again, the child protection system probably points to this, but that being a victim of crime and ending up engaged in the criminal justice system, there is a long pathway. And I don't know the exact stat, but one just has to look at the Royal Commission into Institutional Responses to Child Sex Abuse. The number of people who gave evidence as victims who were at the time in prison was quite striking.
Is the VLA able to comment on any difference of experience as a victim complaining to police for First Nations people in Victoria as to non-First Nations people?
I think there's a lot of evidence in a range of areas about the different experience that people have as victims of family violence, as victims of police misconduct, and the lack of confidence that First Nations communities have in many of those systems.
The submissions also point to civil legal need and the support people need in relation to civil matters such as housing, income, their mental and physical health needs, all impacting on their experience and the impact of the criminal justice system.
That's right, yes. Yeah, again, it's about getting help with those intersecting issues in your life that if they're not fixed, you'll end up having much higher risk of getting engaged in the criminal justice system.
The fourth area that is suggested as a foundational aspect of self-determining criminal justice system is keeping First Nations people out of the criminal justice system, and the VLA has made submissions at page 4 of Appendix A about the minimum age of criminal responsibility. This is a matter that has had great public support been considered at by the federal government, the state and territory governments, with some movement. Are there further comments the VLA would like to make in relation to the need for raising the minimum age of criminal responsibility?
I'm aware that a lot of people have commented on this already this week, so I won't repeat what's been said. I'll just note that in the course of this week, the report to the Council of Attorney General about raising the age of criminal responsibility was released. And if you look at that report, it's yet another piece of evidence about the importance of this reform. And what it makes clear is whether you look at the medical evidence or whether you look at the disproportionate impact on very marginalised children, or whether you look at it from a criminal justice system impact, because the earlier you start in the criminal justice system, the more likely you are to go into the adult system. Or even if you look at it simply as a moral issue, the case for change is very clear. The only thing I would comment on is sometimes reference is made to the common law presumption of dolly impacts and that this provides a sufficient protection for children. This is, I'm sure you're aware, that the presumption that a child under 14 doesn't possess the knowledge to commit a criminal offence, to have the mental element of a criminal offence. And I just say that in our strong practice experience, that doesn't provide sufficient protection because we see children still being arrested and remanded in custody even if they are dolly, if you like, if they should be covered by the presumption of dolly. And that's particularly apparent once you get outside Melbourne, outside of the Specialist Children's Court that Joanna talked about earlier, where it's very inconsistently applied and often not applied in the way that it should be. And so, I can give a recent example which sort of illustrates, I think, some of the shortcomings of this, and I'm being a bit careful in talking about this client experience not to identify them, but this was a recent experience of a young First Nations woman who had a history of trauma, was in the child protection system and had a number of placements break down and ended up in residential care. And during that period where those placements were breaking down, she was repeatedly interviewed and charged with criminal offences relating to family violence and intervention orders. She had a different lawyer, but we first came across her when she was remanded in custody, 12 years old. At that stage, she had multiple intervention orders and 25 sets of criminal charges, more than 25 sets of criminal charges. So we assisted her and negotiated away a number of those charges on the basis that the presumption of dolly ought to apply, that she was not, couldn't be found guilty of a criminal offence. Some of those cases went to contested hearing. We won every case, so every one of those 25 sets of charges was ultimately withdrawn or not proven. But even despite that, on the day that we finished that contested hearing, as she walked out of court, more charges were served on her. So that, to me, just demonstrates that her prolonged involvement in the criminal justice system just demonstrates how dolly Incapax is not doing the job and that there is an urgent need to raise the age of criminal responsibility.
And she was 12
Well,
in residential care.
And we note that Northern Territory have just announced they're moving to 12, that they're committed to, the government there's committed to moving to 12. We would say any move is good, but we would prefer the 14 because we think that that is what the evidence indicates. And I think the report that Dan referred to makes this very, very clear.
There's also evidence suggesting that in addition to a minimum age of criminal responsibility, there should be a higher minimum age of detention.
Yes, that's right.
16.
yes.
Now, I wanted to just ask you some questions briefly about the need for bail reform, and I note from your written submissions that you've identified that in particular there's been a 5-fold increase in the number of Aboriginal women remanded in custody over the last 10 years. That's a fairly shocking figure.
Yes. So we've seen in the past 10 years, but particularly the past 5 years, since the most recent changes to the Bail Act, a very significant increase in the number of First Nations people on remand, but also the proportion of First Nations people in custody as a whole who are on remand as opposed to sentenced. And you're right in saying that the impact has been most profoundly felt on First Nations women.
And are you able to comment on in general terms, on the nature of the offending? Is it serious crime, or does it tend to be low-level crime, or can you not make that sort of?
No, we are, as Louis said earlier, we're in every remand court every day. We're in the bail and remand court every day and night of the year, and the new Children's Weekend online remand court every day. So I can certainly comment. And the particular issue that we see with the current laws is that people who repeatedly commit relatively minor offences, so they commit an offence, then they may be on bail or on some other form of community supervision, commit another offence and another offence, minor offences, end up in the reverse onus situation for bail, may even quite quickly end up in exceptional circumstances bail, which means you have to demonstrate exceptional circumstances to get bail. This is the threshold that was previously reserved for the most serious charges, rape, murder, terrorism, those things. But we particularly see people who aren't facing terms of imprisonment for the offences they've committed, but that we find in custody. And I can give some concrete examples of the kind of offending that has seen First Nations people on remand that we've seen through our services in the past few years. So some of these are, as I said, people who would be on bail or for some other kind of offending, but then commit another minor offence and end up remanded in custody with the reverse onus to get bail. So we had a pregnant woman remanded on 2 counts of shop theft, possession of cannabis, and a charge of failing to appear. A young Aboriginal man experiencing homelessness who was remanded for the theft of a single bottle of soft drink. A young man with an intellectual disability who was remanded for kicking a car because police charged him with the indictable offence of criminal damage rather than the summary offence of willful damage. A young man who was on bail for other matters in the Children's Court doing really well. He turned up to the court for a bail review, but on his way into court, he was found with a pocket knife and a small amount of drugs in his pocket. The Children's Court magistrate hearing that matter said he was doing very well, and rather than those matters being raised before her, he was later arrested and after several hours in police custody, presented at night to the adult remand court. But these are all very real examples of how minor offending brings people into custody. And I suppose to summarise what one of our frontline lawyers said, we just see too many people in custody because of issues in their lives and failures in our systems, not because of offences they've committed. And we know that even short periods of remand are very harmful to people. You know, it's long enough to lose key supports like work and housing, and of course for women it has child protection implications. But of course a short period of remand, a short period in prison is not long enough to get any support or any transition support in prison either. So I think I would say that from the perspective of our frontline lawyers, bail reform is the most pressing issue that they see. And indeed, the Criminal Justice Multi-Party Inquiry made recommendations. Well, it found that our current bail laws are just not targeted to risk properly. And we agree with that. But we would say that the inquiry made recommendations for further review of the bail laws. We would say that we don't need review, we need urgent change to address the number of First Nations people on remand, but also to make sure that the bail laws, and particularly reverse onus bail provisions, are properly targeted to risk, which they aren't at the moment.
We heard evidence yesterday from VALS about their observation that Aboriginal people in Victoria are subjected to over-policing and racial profiling. And by this, it's meant that they are more heavily policed, and more likely to be charged for matters where other people might not. And is that something that VLA can comment on from your observations?
Yes, I mean, I think our Youth Our Way report found that something like 70% of the children they spoke to reported experiences of racism in policing, and they're our clients too. So that rings true and is consistent with the experience of our lawyers. And I think what we see in court every day is the unreasonable exercise of discretion. You know, there's a lot of discretion in the criminal justice system, from whether you stop someone in the street or when you stop them, if you detect them offending, whether you just warn them or whether you caution them, when you charge them, whether you offer them diversion, when you charge them, whether you bail them or summons them, perhaps a decision to bail or remand at the station, and then a decision to go into court and argue for remand or bail. So we see all these exercises of discretion, and we consistently continue to see First Nations clients where we see unreasonable exercises of discretion, and this is why some of those case studies that I've demonstrated are things that we're seeing.
Not just unreasonable, but exercises of discretion towards a heightened criminal justice response,
Yes.
rather than a lesser response.
Yes.
And together, the number and consistency of that exercise of discretion towards a heightened criminal justice response indicates some sort of bias. Would you agree with that?
Yeah, well, I think the degree of overrepresentation has to be explained by how that exercise of discretion is done over a prolonged period of time.
And so you make some recommendations in your written submissions regarding a legislated cautioning system and removing the requirement for police to consent to diversion in a way that brings closer court oversight.
That's right. And I should say, in fairness, a lot of good work is being done. The Aboriginal Youth Justice Cautioning Scheme that Victoria Police is working on now is positive. So a lot of hard work is being done. Again, it's not to criticise individual pieces of work, but we think that some of these decisions require oversight, because we frequently see irrational or unreasonable refusal to give someone a caution or diversion, and we think those things should be properly overseen by courts. So
Councillor McAvoy, just on that point as well, I mean, going back to the bail stuff, I mean, in regional locations, the Justice of the Peace also are part of this process too, at an early point, where bail applications may be being required and what have you. And they're another part of the jigsaw puzzle that are not getting any cultural knowledge and understanding, leading into those other sorts of things as well. But I just wanted to make sure I made comment about that before we lost it.
Thank you. And I suppose the point can then be made is that the exercise of discretion in these ways and the over-policing only serve to compound the difficulties with the bail legislation in the
Correct.
rates.
Yeah, so you don't see a person being remanded in custody for theft of a single soft drink unless there's been a whole range of decisions along the way that's got you to that point. And part of it is the legislation, but part of it is, of course, the way police and others exercise discretion.
Thank you. You also refer to the, in this section, the removal of public intoxication as an offence. We've dealt with that. Item 5 is making imprisonment a sanction of last resort for First Nations people and the reduction of harm in imprisonment. There were whole sections of the Royal Commission into Aboriginal Deaths in Custody report that dealt with the notion that imprisonment should be a sanction of last resort for our First Nations people, and it's disappointing that we're still in this position today. And you, in your submissions, you report to you refer to a number of submissions that the VLA has made, including the inquiry into the Victorian criminal justice system, cultural review of adult correction system, Our Youth, Our Way, statutory review of youth justice, Royal Commission to Victoria's mental health system, Productivity Commission, mental health review, and the National Legal Aid submission, which I assume you're a part of, to the to the Royal Commission into Violence, Abuse and Neglect of Exploitation of People with Disabilities. So these submissions have been made before, is the point that the Commission should take from this.
Yes.
But there are some particular issues that you've highlighted, again, these are generally not new submissions, but the first is to replace short sentences of imprisonment with culturally appropriate sentencing options, so non-custodial options. Yes?
That's right. So
Yes.
most of the world is moving away from short sentences of imprisonment and preferring to support people in the community, particularly because of the effect of the bail laws. Victoria is going the other direction. And as I said before, and as I'm sure is well known, the particular impact of short sentences of imprisonment is positive supports in the community get disrupted, but there's no opportunity for any rehabilitation inside the correction system, and it becomes very difficult to run an effective corrections or youth justice system if you have a large number of people churning through for short periods of time. It's really impossible. And of course, the particular opportunity for First Nations clients is that you can have, there can be strong culturally appropriate or culturally controlled supervision in the community if we tried to keep people out of custody.
The only bit of Corrections Victoria in terms of where mob are sent to that's working well is Wagunganalu, and that's driven by our mob.
Yes, and figures from New South Wales at least indicate that during COVID, when short sentences weren't being imposed, there was no discernible effect on crime rates or other matters. Now, there are a lot of confounding features in the COVID era, but nevertheless, the world didn't stop because they stopped sending people to jail for short sentences. There's a reference to sentencing reform, and we've already discussed the use of Aboriginal community justice reports and the potential for those to be expanded. You've made observations in relation to removing uplift provisions. Can you just explain what you mean by that?
That particularly relates to children's court matters being uplifted into higher courts more readily. And we just think it particularly loses the opportunity for properly, inevitably it escalates children into the adult system more rather than a specialist children's response.
You also, in relation to the youth justice systems reforms, refer to the removal of mandatory penalties and suggest differentiated and age-appropriate responses and outcomes for First Nations children and young people. But those observations would apply across the board, not just for First Nations children. Is that correct?
Yes.
So you recommend strongly repealing mandatory sentencing?
Yes, if we are serious about trying to have individualised and tailored responses to people to try and address offending in a meaningful way and assist people to rehabilitate and re-enter into the community, then mandatory sentencing is fundamentally inconsistent with that principle.
But I wanted to take you to, in particular, I noticed the time to your submissions in relation to healthcare in custody. You've made the observation that you support Val's recommendations and submissions in relation to provision of healthcare and mental health care to people in custody. There's a failure to adequately provide primary health care in VLA's view, or is that not something VLA can comment on.
I don't know that we can comment on the health systems more generally and whether there's a failure to provide. We're more stating the fact that if people need health care and health assistance, it should be available to them. And I think this has been particularly evident for us, perhaps in some instances where a person with a disability has found themselves in a custodial situation, for example, and what they've been able to access that might be part of a normal regime for them, that might be difficult to be made available. But I wouldn't feel confident to say more than that unless, Dan, you're thinking of something particular here.
We've been involved in some of the same coronial matters that Val's has been, where prison healthcare has been an issue, so our observations are probably just consistent with what Val's has observed.
Thank you.
And I think on that one, it sort of goes back to the conversation earlier on about cultural plans. I mean, I think in the correctional setting, that those sorts of concepts or that sort of thing could be rolled out in a way that is more advantageous to the individual in terms of their cultural mental well-being, cultural health, and their health-related matters when they are in custody overall.
Thank you. Finally, I would like to take you to the part of your submission where you address the need for system oversight, justice system oversight and accountability, and the need for an independent form of police oversight. We have heard evidence from other witnesses about this, but it would be useful to hear VLA's view about the importance of independent police oversight.
So we can address that, but we do support independent police oversight, and Lawrence referred to it. It's something we see in a lot of areas. Like, we don't like judges hearing complaints about judges, and we don't like police hearing complaints about police, and we probably see that you need a more arm's length process in order to monitor and assess and give oversight to particularly the actions of bodies that are very vital to healthy civil societies, but have available to them discretion in large part, and can, therefore they're entrusted, I think, with exercising that appropriately, for example. So we think that certainly the Royal Commission into the Management of Police Informants really did indicate in large part that oversight is a very important part of being able to talk and think about proper policing, and we would support the strengthening of independent police oversight as part of that position.
Thank you.
Dan, did you need to cover
You
this?
covered it well, thanks.
Thank you.
Thank you. They're the questions I have in relation to the VLA submission, Commissioners. Are there any questions that you have of the witnesses?
No, thank you. I've asked them along the way. Thank
I
you.
have no questions, Chair.
No further questions.
In that case, Commissioners, I tender the Victoria Legal Aid's submission, Systemic Justice in the Criminal Justice System, dated 21 October 2022, and that's document 8.2, and the documents which follow, including the submission to the Yoorrook Justice Commission, Systemic Injustice in the Child Protection System. And Commissioners, you will note that at the end of the list of documents that are tendered, we have included the additional document with further background information on the Victoria Legal Aid, and the Victoria Legal Aid final evaluation summary, which was spoken to during the course of evidence. There being no other matters for these witnesses, Commissioners, I ask that they be excused.
Thank you. Thank you.
Commissioners, we have gone over time. I'm grateful to you for sitting a bit longer. We have further witnesses at 2 p.m. If you wish to start at that time, it's now 20 past 1.
Yes, I think 2
We'll have to.
p.m.
Yeah,
Yes.
we'll have to. Yeah.
Thank you.
Thank you. Thank you, Commissioners.
We adjourn until 2. Thank you. We good to go, Council?
If the Commission pleases, this afternoon we have the Human Rights Law Centre and the Centre for Innovative Justice to speak in the criminal justice context about what needs to change, examples of good practice, and what's preventing much needed changes. I'll swear the panel members in.
Thank you. We're pleased to welcome you today. Thank you.
We'll start with Nick Espy from the Human Rights Law Centre. Nick Espy, do you undertake to give truthful evidence to the Yoorrook Justice Commission today?
Yes, I do.
Monique Hurley from the Human Rights Law Centre. Monique Hurley, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes, I do.
And Stan Winford from the Centre for Innovative Justice. Stan Winford, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes, I do.
Rather than witness statements, both centres have provided detailed submissions, which I will tender at the balance of this panel session. If we can go back to you, Mr Espy, will you introduce yourself personally and professionally, and in particular, if you would explain your recent experiences and work in the Northern Territory, and I understand after that the centre would like to make an opening statement.
Yes, and thank you, Commissioners, for letting us speak here.
Sorry.
Sorry,
You're right. I'm a lawyer. I'm an Aboriginal man. I'm an Islander man from Central Australia. I'm working as a director at the Human Rights Law Centre as a legal director. I'm here with Monique Hurley, who's my colleague, also working for the HRLC. We work nationally across the country. Although I'm based in the Northern Territory, the work we do includes, and historically the organisation's done a lot of work here in Victoria. Can I acknowledge the Wurundjeri people of the Kulin Nation, the traditional owners of this land, and pay our respects to their elders past and present. So I've been a lawyer for more than 20 years, practising in both the Northern Territory and Western Australia, and that's included starting my career in prosecutions in my hometown of Alice Springs, and then working primarily in defence, criminal defence, as well as other areas of law, including child protection as well, across Northern Territory and also the Kimberley region of Western Australia. I worked from shifting from criminal practice more to policy and advocacy work. I started working on the Royal Commission in the Northern Territory. That was the Commission into Youth Detention and Child Protection. From then, I was employed in the Northern Territory Government managing the law reform that was subsequent to that Royal Commission, saw the implementation of legislative reforms in youth justice and child protection before working back in NARJA, which is the Aboriginal Legal Service in the Northern Territory, and then coming to work at HRLC. Frustratingly, seeing important reforms in child protection, and in particular in the youth justice space, using my own 20 years of experience as a lawyer, 20-something years of experience as a parent of Aboriginal children, implementing or writing recommendations, being part of that process, then implementing important law reform, and the frustration of watching that deteriorate and be wound back, and regressive laws that were contrary to the wealth of evidence that was gathered during that Royal Commission is something that is extremely disheartening and frustrating. So I guess it's something, words of caution that for yourselves to consider how to make and create recommendations that will bring lasting change, and something concrete that can't be wound back and dismantled. So that's just something to say. HRLC, we're an independent, not-for-profit organisation. We're non-government, we're independently funded, and that's an important aspect of our work, so that we can, in giving, in the advocacy we do, we can be independent and not have the fear of biting the hand that feeds us, which many Aboriginal organisations, in my experience, nationally have that fear. Our work is we work in solidarity with Aboriginal people and organisations to address systemic injustices. We acknowledge the powerful work of VALS, who I think I've already given evidence here. That's an organisation that we often partner with. We endorse their submission to Yoorrook. In particular, we support their calls for the Victorian Government to negotiate a treaty with Aboriginal and Torres Strait Islander people, communities and organisations, and to set a new foundation to transform our criminal justice system. For years, governments spend more money on police and prisons and expand those processes, not just in Victoria but across the country, on the false premise of, tough on crime and more prisons, more police is going to create community safety. My experience over the course of my career, the experience of the work that HLC has been involved with is, and obviously there's a body of evidence that we know that's not true. So those approaches of just more police and prisons, I guess, we know it doesn't work. It's a shame that we have to be discussing that at such an important truth-telling event, but the fact that for Aboriginal people across the country, just getting justice shouldn't be a starting point. It's a hurdle to so many other things. And I guess just touching on what I said before about the experience of the Royal Commission I worked on, and as well as many other commissions and inquiries, is that often they identify evidence-based solutions to the repeated systemic failures of government and government agencies. The solutions identified always include resourcing, enabling the Aboriginal sector for co-design and participation. However, when it comes to implementing any recommendations, it seems that government agencies responsible for systemic failures that let down our people, their punishment always includes increased funding to implement and address these things, which inevitably then gets wound back, and then they sort of go back to this same starting point. There's always recommendations that they engage and allow the sector to participate, but there's always a failure in doing that properly, a failure to resource the Aboriginal sector sufficiently, or to listen to the Aboriginal sector. And unfortunately, the motivation that comes from things like this is often dwindles, and recommendations are either ignored or only partially implemented, and as I said, or subsequently repealed. So, sorry, I'm going on, but just the reference to the recent work in the Northern Territory, a piece of work that HRC has been involved with, still involved with now, is the inquest into the police shooting of a young man referred to as Kumanjai Walker, who was a young teenager in the community of Yuendamu. This is another instance of governments failing to proactively act on evidence and take steps to address systemic injustice. Unfortunately, Aboriginal people and organisations are forced to respond to these sort of tragic deaths, and working in this space of advocacy, it's a cruel irony that you're often waiting for another death, whether it's Kumanjai Walker or Miss Tanya Day or Miss Nelson, waiting for the opportunity to create momentum for change that there's already a wealth of evidence around that. So it's that tragedy of not only people in justice advocacy, but the Aboriginal community. It's that question of whose mother or whose son's going to be next, and then unfortunately having to seize that opportunity to try and say, well, this is why we need to create change. I'll just pass to my colleague, Ms. Hurley.
Thank you, Nick.
Just briefly introduce yourself professionally and then any further opening comments you wanted to make.
Thank you. It's a real privilege to be here today. My name's Monique Hurley and I am Nick's colleague and a lawyer at the Human Rights Law Centre. I've got 10 years experience working across Victoria and the Northern Territory in Aboriginal legal services and community legal centres. And that's, what I'm bringing here today. So alongside the need for transformation of the criminal legal system that I know that you have heard a lot of evidence about, and particularly from the Victorian Aboriginal Legal Service, there is urgent need for the Victorian Government to take action and reduce the number of Aboriginal and Torres Strait Islander people experiencing injustice at the hands of the criminal legal system. With the stroke of a pen, the Victorian Government could make changes that would have both an immediate and intergenerational impact, and a brave Victorian Government would be working towards a future without people in prisons. And this starts with, we've identified 4 priority reforms from our perspective. Firstly, the Victorian Government must raise the minimum age of criminal responsibility from 10 to at least 14 years old. No child should be in prison, but right now children as young as 10 can be locked away in Victorian prisons and police cells. The current incredibly low age of criminal responsibility contributes to the overrepresentation of Aboriginal children in youth prisons and is out of step with the rest of the world, international human rights standards, medical science and the criminological evidence. So following the lead set by the ACT, the Victorian Government must do the right thing and raise the age. Secondly, we say that the Victorian Government must overhaul the state's bail laws, which are currently resulting in unsentenced Aboriginal people being locked up in pre-trial detention at really alarming rates. Knee-jerk changes to bail laws that have disproportionately impacted Aboriginal people and Aboriginal women the most are needlessly removing women from their families and funneling them into prisons where they're getting trapped on remand. To fix this injustice, the Victorian Government must repeal the reverse onus provisions in the bail laws as a matter of priority. Thirdly, the Victorian Government must end the status quo of police investigating police. While the government has invested significant amounts of money into expanding and militarising the state's police force, there has been no commensurate increase in accountability. For too long, police have been able to act with impunity and dodge accountability for misconduct and discriminatory policing, along with deaths in custody. To address this, the Victorian Government must properly resource an effective and independent police oversight body in the form of a best practice police ombudsman. And finally, in terms of priority areas for action, the Victorian Government must get public intoxication reform right. The government's commitment to repeal public intoxication laws is testament to the tireless advocacy of the Day family, Belinda, April, Warren and Kimberley, and activism and work done by Aboriginal communities in this state since the Royal Commission into Aboriginal Deaths in Custody handed down their findings in 1991, and the government owe it to them to decriminalise public intoxication and replace it with a best practice Aboriginal-led statewide public health response without further delay. And as the Day family have consistently said, for these reforms to work, there must be a full transition away from the current criminal law approach to a genuine and best practice public health one that does not involve police. Thank you.
Thank you. And Mr. Winford, I invite you to outline your professional background and explain the work that the Centre for Innovative Justice does.
Thank you. Yep, I'm a lawyer and also a policy worker, and I have been involved in working on a number of projects with Aboriginal communities, which are mostly aimed at bringing about their vision for self-determination in justice. And our centre's work is really about exploring innovation in the justice system and thinking about lived experience and how that can influence better policy design. And our objective is to really expand the capacity of the justice system to meet the needs of diverse users, and where possible to be a positive intervention in people's lives. And our centre is also very focused on practical outcomes, so testing, piloting, implementing some of the ideas that we look at, including restorative justice and therapeutic jurisprudence. Our work involves work with victims, with family violence services, women's decarceration and disability in the criminal justice system, and looking at how human-centred design can deal with legal issues and processes. And we do a lot of work with government, with courts and tribunals, with non-government organisations, community organisations. We have a service called Open Circle, which delivers restorative justice processes for people and also designs restorative programs. And we also work with law students, so we lead study tours looking at innovation internationally. We also teach, and I teach a subject called Innovative Justice in the RMIT Law School. And recently we've been working with the Aboriginal Justice Caucus, with the Rajak, with an organisation called Wudungun, and with JIRA and VALS.
Thank you. If we can start now with what needs to change, Mr. Espy and Ms. Hurley, the Human Rights Law Centre's submission calls for the closing of prisons, not building new ones. And we heard this morning from Auntie Vicky Roach, and this is a call for reform that she's been making for some time. It sounds radical. What do you say needs to happen to make this a reality?
Real privilege to hear from Auntie Vicky Roach this morning and really echo her calls for action. I think that for too long, successive Victorian governments have been spending millions and millions of dollars on building and expanding prisons that the evidence, a mounting body of evidence is really showing don't work, and that they actually even undermine community safety. That's something that the recent Victorian inquiry into the criminal legal system found. They confirmed that in terms of saying that the current kind of punitive approach to law and order and locking everybody up isn't working, and that we need to be thinking about different approaches. And I think that that's really, really important, and really, it's an exciting opportunity for a truth-telling commission, this kind of forum, to be thinking about really ambitious and bold ideas for change, and thinking about how do we work towards a future where there aren't prisons that are really harming and hurting people in the ways that Auntie Vicky Roach spoke about this morning. Really, prisons have a really harmful effect on people. There have been death traps for over 500 Aboriginal and Torres Strait Islander people who have died in custody since the Royal Commission into Aboriginal Deaths in Custody in 1991. And earlier this year, 2 Aboriginal men died in prisons within, a 6-week period. The fact that we live in a state that allows that to happen and that that's not treated as a crisis is really, it's shameful and it's appalling. And for those that survive prisons, people like Auntie Vicky, the stories that they recount and the experiences that they have in terms of being subjected to practices like solitary confinement and routine strip searching, it's really easy to understand how, that system isn't working, and that we need to really be thinking about new and different approaches, and that starts with not spending money on prisons and investing that money in alternatives, and thinking about what those alternatives can look like, how they can build stronger communities, how they can support people, and how they can address the risk factors that cause people to be criminalised by the current systems in the first place. And that's, in this context, looking at self-determined solutions and investing in those.
The Human Rights Law Centre has also called for independent oversight into the police. Can you explain what the centre thinks that should look like?
What we would recommend is an independent police ombudsman, and I think the best practice example is that of Northern Ireland. It needs to be independent of police. What we see not only in this jurisdiction but across the country is police investigating police just doesn't work. It's too much of a conflict of interest. It requires investigation from independent citizens that are properly resourced. It's something that does have to be properly resourced. Other issues that we've come across is the timeliness of complaints, not being investigated thoroughly and timely, speaking to witnesses in a timely fashion. An independent police ombudsman needs to be transparent, open to public scrutiny, so that it's obvious what's happening. In the case of Aboriginal people, culturally appropriate systems in how police matters are investigated.
And the submission also calls for amendments to the Charter of Human Rights and Responsibilities to introduce self-determination and also economic and social rights. We've heard in the evidence, not specifically in relation to the Charter, but in general, that there's a real issue with First Nations people enforcing and even knowing that they have the rights that they already have. Would amending the Charter alone be enough to see these rights being protected?
So I think the Charter plays a really important role in helping inform government decision making and making sure that a human rights lens is applied over government decision making. And we, as you point out, we support the call from the Victorian Aboriginal Legal Service for the right to self-determination to be enshrined in the Charter. I think that amendments to the Charter can help Aboriginal people access justice, and I think some of the ones that you pointed out are important. I think that a standalone cause of action and access to appropriate remedies would also be of significant assistance in terms of, at the moment, if you want to run Charter arguments in court, you need to piggyback them onto an existing cause of action. And so you need to be quite strategic in your thinking in terms of identifying a principal cause of action that you're then going to attach your Charter arguments to. And that does create accessibility issues for everybody, and particularly for Aboriginal and Torres Strait Islander people. And so those kinds of reforms are really important. But I think that it's not the Charter in itself, and making it as wonderful and as robust as it could be is not going to be a panacea to the issues that are being raised before the Commission in terms of the changes that need to be made to the criminal legal system, and that's why it's really important that that kind of work is done alongside the broader calls for more transformational justice in terms of considering how all of the different kind of government systems in the first place are resulting in systemic injustices, and so doing that work alongside each other is really important.
Turning from what needs to change to examples of good practice. Before going through the examples, Mr Winford, the Centre's written submission sets out some key insights that have come out of the Aboriginal-led projects that the Centre has undertaken. And your submission lists those as being, firstly, that positive outcomes are achieved when Aboriginal communities lead change. And the second is that power and resources need to be shifted from government back to community. And the third insight that you've shared is that the voices of people with lived experience are critical for change. Can you tell us firstly, with those insights in mind, about the Yalum Yalum project that the Centre collaborated on and what you think has been important to its success?
Yep, certainly. So the Yalum Yalum project involved our centre being engaged by by VACSAL, the Victorian Aboriginal Community Services Association, and the Grampians Rajak to make recommendations for an independent self-determined justice model, incorporating an Elders and Respected Persons Council to be known as Yalum Yalum. And the model that was developed by the community was a process for referring community members to an Elders and Respected Persons Council that would promote cultural healing, social and emotional wellbeing, and a stronger role in culture and community. And the process aims to provide an alternative that diverts people away from further involvement in the criminal justice system and address overrepresentation. Part of the work involved co-design with the community, where the community initially began with its vision for what this alternative model would look like, and some values that would underpin that model. And the values were self-determination through community control of both the process and the outcome, and the community felt that they should have control over those aspects, and it should be run by the Elders and Respected Persons who would sit on the council and determine outcomes. Enabling voice of ancestors, elders and participants was seen as important, and it would involve honest and open communication between the council and the person before them. And it was thought that the process could be held at the Gulum Gulum Aboriginal Cooperative and be moved on country if there was sufficient resources to enable that. And it would involve cultural protocols, including welcome to country and other cultural elements. And the council process itself would enable community members to identify and connect with culture, set cultural milestones and acknowledge and celebrate when those milestones were met. The community had an interesting view about accountability, which in criminal justice system means something, often means, punishment and so on. For the community, they felt that the participants would be held accountable to the community, and it would relate to their strength and the relationships that they would develop within the community. It was thought that the council could provide problem-solving outcomes for people, and that people wouldn't have to admit guilt but would acknowledge obligation to the community. So those were the vision and values. They were established through a co-design process, and importantly in the design process, that community involvement was separate from discussions with the justice system stakeholders, so with the courts and police and so on. And it was felt that it would be important to enable the community to establish their own vision for this process and then to come to the formal system and indicate what they required of the system to enable that to function, for example, referral processes and so on.
And Mr Winford, you speak a bit about that in the submission, and I think it's a really important issue to highlight in the co-design process, that just having community members in the room with a whole lot of judges and justice system people is not necessarily going to be effective, because those people are used to sitting silent in rooms with judges, and that in some ways they need to be separate and allowed to have their ideas in a space where they feel free to communicate.
Yeah, that's exactly right. I think these processes require, often we've worked in this way with other communities, and one of the critical things is about enabling people who are often marginalised and dispossessed to take power back in terms of determining their own solutions. And when conventionally the experience of people might be to come into a courtroom and bow to the magistrate or judge and to be silent, those dynamics are to be avoided in those processes. And I guess also, even in our experience working with the community, it can be difficult to think outside the square, think outside what's been customary practice in people's experience of the justice system, and to sort of give space for those community values and that vision about the strengths and resilience of the community to come through. But I think in this case, it certainly occurred, and people, were really thinking about what is it in our community that we can do that would enable us to contribute to the community and to understand who we are in our culture. And people came up with some really great ideas about cultural activities, including working with the Barangi Gadgin Land Council on cultural burning and water management, working in the nursery, looking after country, which was seen as a really positive way of addressing their obligation to the community. There was discussions about how that could lead to employment, for example, as a ranger, as well as just an outlet for people to heal and reconnect with their country and with their community. And of course, things like community counselling, men's and women's group, social and emotional wellbeing, even mowing the lawns for elders in the community were seen as things that could be done as part of the participant connecting back with their community through this process.
The other work that you've been doing that I was hoping you would share with the Commissioners, Mr Winford, is the work the Centre has been doing with the Aboriginal Justice Caucus to reimagine the current system of youth justice.
Yeah, so we've been very privileged to be able to work with the caucus on their vision for youth justice. And again, it's a really striking vision when it's compared with what we currently see in the system, which is one that seems to inflict further trauma, in which abuse and further harm seems to be endemic. If you look around the nation, whether it's the Northern Territory and Dondale or Banksia Hill or Ashley Youth Detention Centre, each of those environments have really, despite being closed environments, the abuses and the further trauma that's occurred within them is really evident. And those are systems which seem to prefer stability and security over rehabilitation, and often the response to issues that arise is about restrictive practices and, convenience operationally over the needs and interests and welfare of the young people within them. The caucus vision for the youth justice system was one which was controlled by the community, that focused on healing and therapeutic approaches, that promoted social and emotional wellbeing and strengthened connection to family, community and culture, that it would offer support for health, mental health, disability, alcohol and substance abuse. The caucus was also really clear about what community-controlled alternatives to youth justice custody might look like, and they were really interested in examples in Canada where there are healing lodges, in Spain where there's a response that's provided by the Diagrama Foundation, and even our example here in Victoria of Wollongongano Nalu Learning Place. So each of those ideas, they're supported by research and evidence about what's effective with young people, but they also align with the community's vision for what justice should look like.
Mr Winford, the Centre's submission talks about the importance of lived experience in co-design, and the Human Rights Law Centre has also mentioned the importance of co-design when driving reform. And we heard this morning from Auntie Vicky Roach, who spoke very powerfully about her experiences of these systems and what she thinks needs to change. Why does the Centre for Innovative Justice consider that people with lived experience need to be involved in redesign processes?
Well, for many reasons. I think it's a good way of developing policy because people closest to problems are closest to solutions, and unfortunately they're often furthest from resources needed to make change. So part of working with lived experience is ensuring that those voices are heard in ways that they haven't been to date. And I think if you look at any system, whether it's criminal justice system or youth justice, most of the problems with those systems relate to the fact that the people that they're supposed to be achieving outcomes for, whether it's rehabilitation or otherwise, have never really been part of contributing to how they work or don't work. And I think it's also respectful of people's dignity as human beings to involve them in decisions that affect them. And I think that participating in the design of systems and processes is important for people's dignity and to help them heal. So, I mean, the third sort of reason that I think I've seen in many contexts is that the power of people's direct experience is far more persuasive than anything I could say about how or why something needs to change. I think people at the centre of systems can cut through in a way that reports don't. And, you know, that was the case in the Dondale Royal Commission. It's been the case in a lot of the work that we do with people with disability in the criminal justice system. It's been the case with many social change movements when people who are really directly affected by the failures of systems are able to speak about them directly and people can hear from them about the pain and trauma that they cause. That can be a very powerful and effective form of advocacy.
The final part of the Centre submission that I would like to ask you to speak to, Mr Winford, is about self-determination in justice. And you have pointed out that the UN Declaration on the Rights of Indigenous Peoples in fact acknowledges the right of Indigenous people to live by their own law, to make law and administer law. But you've also noted that there is a perception that self-determination in this area is a direct challenge to the state's authority. From a policy perspective, what does the research indicate about whether self-determination in the justice system is effective in achieving positive social and economic outcomes?
Oh, the research is very clear that self-determination leads to very positive outcomes, both in justice and social and economic senses. I've read several reports about that, including meta-analyses about other bits and pieces of research. And it's really clearly the most effective way of addressing policy problems and challenges for communities. And to me, that seems to make sense because, for a start, going back to the point I made earlier about people knowing about what the problems are themselves, those are the people who know how to solve them as well, and they just need to be given the power and resources to do that if they don't already have them. And I think the failures of our system at the moment reflect that because we have a very one-size-fits-all justice system that doesn't allow for local solutions or community-led solutions in a way that might work in one place but not in another. So there's a great deal of benefit in that level of expertise being able to be delivered locally to tackle complex, multifaceted problems.
What mechanisms have been used in other jurisdictions to provide greater self-determination in the criminal justice system to First Nations people in particular?
Well, in New Zealand, the Treaty of Waitangi has had an influence on that, and I mentioned before that our centre takes students on study tours, and I've seen some incredible courts that seem to be very much led by First Nations people. So the Rangatahi Youth Courts are a terrific example, which begin by people being sung on to a marae, a Maori meeting place that involve young people, Maori people, speaking at pipiha, which is their cultural identity, and learning about that and developing that over a series of meetings with the people, with the judges and community leaders. They involve really terrific practices that I think First Nations communities here often demonstrate, that involve bringing people together to solve problems in a way that is very different from my experience as a former criminal lawyer, going to the magistrates court and seeing the stress and the conflict and the argument and the adversarialism played out in very unhelpful ways. In the Rangatahi court, all of the participants in the court, including the judges, including the youth workers, even the police prosecutors, meet together and share, a cup of tea and a scone before they go into the hearing. And the sort of sense in which the work is being done is very different to my experience of adversarial courts. So I think self-determination can work very well, but it also needs some infrastructure around it. So in New Zealand, for example, there's obviously legislative changes that reflect self-determination, but there are also changes in relation to funding and resourcing for Maori-controlled organisations. So they have a commissioning agency which is separate from government, which works with community-controlled organisations to fund and develop programs which might address, the needs of young people in the justice system, for example. And those efforts seem to have been very effective, and they're, obviously led, run, resourced by the community.
Can I just ask a question there? It's just a bit of a clarification between co-design and self-determination. Yep. That I worry a little bit that these two things might be conflated. Can you explain to me what you see as the difference in those two approaches? Yeah,
well, I think co-design is probably more about power sharing between potentially Aboriginal and non-Aboriginal people around the design of a system or a process. Self-determination wouldn't necessarily involve non-First Nations people. It would remain entirely a process that was held and controlled by the First Nations community.
You can't have co-design self-determination.
Well, I mean, the way that I've been involved, I think, in some of the work that we do, I guess you could call it's design, in that we're exploring how to improve a process or how to develop a process, but I'm not telling the community what to do. The community is telling me what they want to do, and I'm bringing my, what expertise I may have in the justice system to help that community achieve its aspirations. And the community can do it itself, or they might want to draw on some of the expertise that I might have to offer.
And one of the points I think the Commissioner is getting at is that we currently have co-design within Victoria operating in a model that does not involve self-determination, but where a specific project is handed over.
Yeah, so I think, sorry, if I'm understanding correctly, I think thinking about co-design usually, and we're working on frameworks, for example, for the Department of Families, Fairness and Housing around the forensic system and how the voices of people with lived experience can be incorporated into the design of policies and programs in that system. And when you look at a framework, you can look at a continuum of different levels of participation by the people who don't have the power, in this case, people within that system. And it begins with things like consultation, like, government often consults and says, we'll tell you about what we're doing. But the extent to which that people have feedback and that feedback will be acted upon, it moves towards something that's much more empowered. And yes, people, particularly, dare I say, in government, use that term, and it doesn't mean what I would think it means in terms of the power and control that a community would have over the outcome and whether they're listened to.
And the co-design is never defined, is it?
No, that's very true. Yep.
Returning to the Human Rights Law Centre, your submission discusses two particular things that you say, are blocking change at the moment. The commissioners have heard a lot of evidence about things that need to change, and they are things that indeed the community has been speaking about for decades, if not longer. One of those blockages that you mention in your submission is the influence of the Police Association of Victoria on state governments, regardless really of what party's in power. What role do you see TPAV playing in the development of justice policy?
I guess I would say probably too much of a role. Police associations, not just in Victoria but across the country, really do act as lobby groups, and we endorse Val's recommendation that they should be treated as such, because and essentially we would say most of the positive reforms that we as an organisation have advocated for are constantly challenged and blocked by police associations, if not the police. An example is the reforms into public drunkenness, where there's collaborative working groups co-designing with the relevant government agencies, and you not only have police representatives, but you have the association representatives as well, who are often in conflict with each other, either quite obviously or discreetly behind the scenes. So that's extremely concerning, that you really should have the one voice speaking on behalf of police issues, but when police themselves, it's quite apparent that there's this constant undermining by the association. It not only prevents positive reform, but it's people in the Aboriginal community seeing that it's quite alarming and frightening that there is no kind of genuine power structure. It's undermined, constantly undermined. An example of that in the recent inquest that we've been working on in the Northern Territory in relation to the Police Association is that senior members of NT Police have given evidence explaining how, and this goes back to the issue about problems with complaint mechanisms and disciplinary proceedings, that even the most minor things that should be relatively straightforward, where there's been a complaint or there's been an issue that should be addressed, so that a young officer can learn the lesson of what they may have done wrong, receive some sort of discipline and some sort of re-education, and then just get back to their job. There's this constant situation of trying to prove their innocence and that they haven't done anything wrong, and that can create quite a dangerous situation. Without commenting on that matter in any detail, it's to an Aboriginal person that's receiving the rough end of that undisciplined behaviour by police officers. What we know, not just in this jurisdiction but elsewhere, is it can lead to lethal outcomes as the worst examples of that. So yeah, just going back to, we do endorse the submissions that I believe Vals have made around police associations being treated as lobby groups, having some transparency around when they meet with ministers and agencies, etc. I won't repeat their submission.
And just to add to that, so Nick said that the Police Association is publicly opposed to best practice public intoxication reform. They're also on the record as being opposed to raising the age of criminal responsibility from 10 to at least 14 years old. They're opposed to reforming bail laws, and they're also opposed to implementing best practice, or ending the practice of police investigating police, which are all key and shared reforms that that we're advocating for and that organisations like VALS have been advocating for some time. And I think that just to add to what Nick was saying in terms of it really stokes this tough on crime situation that we find ourselves in Victoria, where successive governments have really been stoking fear-driven politics around criminal legal system reform, and that's been fuelled by the Police Association and public comments that they make that misstate what progressive reform would look like, and that they're very effective in making claims that invoke fear as the basis to resist any winding back of police powers, and stoking spurious stoking spurious narratives about the drivers of crime and effective solutions.
On this issue of tough on crime politics, I might ask you all, is there a way to approach reform so that this bipartisan race to the bottom can be circumvented?
I guess just calling it out as nonsense. I had another word in my head, but the term political football, particularly when you're, come from a minority community such as the Aboriginal community, you see it every time there's an election. You see it every time there's this knee-jerk reaction to a tragedy, where it's used as an opportunity to create punitive reforms that persistently affect people living in poverty, people from the non-white community, whether that's Aboriginal people or people from other migrant communities. So I guess calling that out, and actually, as we've talked about before, looking at involving, the term lived experience is used, but affected people is perhaps a better way of describing it, because it's not just, the Aboriginal person that's experienced violence by police or had a traumatic time in prison. It's not just those people that have a voice and have a role and have the experience. It's the family and the community that pick up the slack and are generally, when I look at the time of my last 20 years of being a lawyer, the people that succeed in breaking their own cycle and becoming rehabilitated are people that have had family and community supports, that pick up the slack of the insufficient services provided by government or the gaps in services or the lack of programs. It's families and communities that help their own people succeed because they're affected, because they know what it means when it's a relative that's experiencing trouble. They don't have to tiptoe around whether their nephew or their cousin or their neighbour was unjustly treated by police or by, because they don't have to worry about tiptoeing around the word racism, because they understand it. It's a general fact of life, so they can just get on with, well, all right, you may have been treated racist, but this is what we need to do to help you in this situation. So I guess that's that issue of co-design or self-determination. It's where rather than what do we do to make prison a better place, self-determination is the community saying, well, we don't even want to be involved in talking about how to fix prisons in our community. We need A, B and C, and we want to talk about those things because we know you address these issues around our education in our school or a health service that picks up people that are intoxicated rather than them getting arrested by police. We want to talk about those things because we know that that's going to assist us and help address the issues in our own communities.
Commissioners, or Chair, sorry, those are all of my questions. Do the Commissioners have any questions?
Well, I certainly do. It's very hard some days listening to some of this stuff, and I have to say it feels like somebody's thrown a jigsaw puzzle of gloom on the floor, gloom and doom, and tell our people to go out and pick up a piece and see where they end up, let alone thinking about respect for individual human rights or the rights of children. And I've got two questions actually, and one is about the collaboration exercise. I won't use co-design, I'll use the word collaboration exercise you described in the Wimmera. And the other one is about training, which I would like to ask you in relation to your own preparedness for what you are now doing. So collaboration, is there room, much more room for collaboration in the way that you have done this work in the west of the state? I mean, there's so many bodies out there, there's so much money thrown, it's a bit like, you know, throw the money on top of the jigsaw puzzle and everybody gets busy. Could you comment on collaboration or more collaboration or anything against it for that matter?
Yeah, I think more collaboration is better than less collaboration for sure, and that's because all of these issues are not just justice system issues, they're issues across lots of different dimensions of people's lives, and the solutions require whole communities and lots of different areas to be part of the response. And I do think that sometimes the way government, for example, funds things doesn't support collaboration, in that every community organisation is probably under-resourced and underfunded, and they're often competing for a small pool of funds available, whereas what you'd hope to see was ways of financially supporting collaborative approaches to solving problems. I think the way government works and the way even some philanthropic organisations fund things does not support that form of collaboration. Maybe there needs to be different structures to support that. Having said that, the project that I talked about, Yalum Yalum, arose as a priority of the Aboriginal Justice Caucus and for that regional committee. So there was collaboration in the sense that everyone agreed this is a priority for us. We would like to develop our own self-determined justice response instead of, for example, having a Koori Court in our region. Yeah.
Thank you. And any comments on training, because you know it's come up before about training of lawyers, and I mean I think in the legal profession you probably look at old law rather than what's the transition that's happening in law in modern times, and certainly in our spaces.
Yeah, absolutely. I think personally always learning as much as I can about the community, and really derive a lot of benefit from the wisdom of elders that I've worked with, and indeed Commissioner Hunter has delivered some training for me and other partners in the work that we've done before. I think it's absolutely critical for people to have a greater awareness of Aboriginal culture and indeed the historic process of colonisation and what's occurred. And you know, people of my age didn't get any of that through our schooling, and unfortunately we've all had to go out and learn about it ourselves and learn about it from our colleagues. And I've got a number of members of my team who are Aboriginal community members, and I learn from them all the time, but equally I recognise that it's not their job to teach me. It's my obligation to go out and learn more. As a person going through the law school at Melbourne Uni, absolutely nothing. And probably the closest we ever got was starting to learn a bit about native title because the Mabo decision came down when I was at uni. And certainly in the work that I now do, we, through the RMIT University, where I contribute to teaching law students, we're really trying to show people and educate students about Aboriginal culture where we can, and show them the workings of the Koori Courts and the Aboriginal family hearing days at the Children's Court and various other options. But yeah, so much more needs to be done for that to improve however it works around these issues.
Nick, I'd be interested in your view too.
Yeah, look, I guess just not the opposite, but I guess I think the question is focusing on more on how do we train and get better education and support for Aboriginal people to get into professions like law and medicine and everything else. How do we flood the education system with resources or communities with resources to do that, whether that's scholarships or culturally responsive programs. And I think you may have another witness or speaking to that issue later today, but I guess my own experience was being lucky to be involved in a pre-law bridging program 20-something years ago, and which was bridging or a gateway into to studying law, but reaching out to people that aren't necessarily don't have the same access to education as other people in the community. I went to a very tiny law school and I've walked for half an hour in the Melbourne University and thought this has got more bricks and pieces of steel, etc., than some of the small towns and communities I've lived in and visited in remote parts of the country, and just that, a vast difference between where a lot of people and I, make assumptions on rural Victoria, but certainly the places where a lot of our mob live and grow up in, but having people be able to learn to be lawyers, etc., and then influence not only the justice system, the judiciary, their colleagues, but having that influence rather than having to train or retrain people that are already in that profession. And I guess just examples of that is what people value in the knowledge that they gain. I worked for 12 years in the Kimberley, which is not my community, but the assumption that a lot of non-Indigenous lawyers made about my knowledge, intricate knowledge of people in the communities and family connections and historical issues, they weren't things that I grew up in knowing about that community. I have connection to that community, but I didn't grow up there. But from my own life experience I see value in understanding who the elders are in this community that I work with. Who do I approach in the community to understand who's going to successfully help my 16-year-old client rehabilitate himself and get help, because I know the locally funded non-Indigenous programs not really going to be effective, or they just don't exist. So who do I go to in that community, knowing who the extended family of people are in a community, because that's going to help help that same kid reconnect or connect with a positive family member that's going to steer them on the right track. Knowing who to speak to about doing submissions around law reform or community development, because people that have the history of a town or a community. So those are the values that you sort of learn, or things like understanding family relationships and why one family member may not be able to speak to or assist another. So all those cultural intricacies that, if it's not your own community, you have a better understanding from your own cultural background, I suppose. I think focus on creating more Aboriginal people working in this space.
Thank you. Monique, did you want to say anything at all about your training?
Not a lot of training through university, and when I hear about the work that Dr. Cabillo's doing now at Melbourne Uni, I think it's really important and really incredible work.
Thank you. Sue?
No, I'm good, thank you.
Yes, two questions, thank you. We have received evidence from others about the pressing need for a change to the system for police oversight in favour of a fully independent civilian-controlled system. And evidence has been given about what of confidence in the present system to deliver fair outcomes for Aboriginal people complaining about police conduct. And I wanted to ask you about that question. Do you have confidence in the present system to deliver fair and objective outcomes for Aboriginal people complaining about police conduct?
Short answer would be no, not a lot of confidence from experience. There's challenges of people wanting to, Aboriginal people wanting to make complaints. When people come into contact with the justice system, there's some other conflict or challenges in their life, and often, and I'm speaking generally because I haven't practiced in Victoria, but also the experiences of our organisation, that people just want to address their issues and sort of get on with life. But the number of matters that should be complaints that aren't are very concerning. There's always issues of timeliness and the slow nature of the complaints process, and there's also the reluctance of police investigating and disciplining their own colleagues, as well as the issues raised about the toxic influence of police associations. That I think those things in combination, I'd say they just address the issue of why we need independent police complaints mechanisms. Anything I've missed there?
Monique, you're in Victoria.
Yes, I would say that back when I did a lot more direct service delivery, I think when you explain to clients how the process works, and that even though that there's IBAC, and that IBAC technically has the function that it can conduct and have oversight of complaints made against police, when people understand that the vast majority of those complaints are going to be referred back to police for the police to investigate the actions of their colleagues, like the chilling effect that has on people even wanting to engage with the process to begin with is immense. And so I think that I don't think that anyone can have faith in the current system, and I think that that's been confirmed by a lot of the evidence that the Commission's heard, particularly from VALS, and there's studies that have confirmed that particularly Aboriginal people are distrustful of the current system, and that they're not making complaints, and when they are making complaints, there's like systemic racism within that in terms of how the complaints are being investigated and dealt with.
I guess there's a genuine fear. Many Aboriginal people have an inherited, and it's reasonable in many circumstances, fear of police and interactions with the police that have, if not been negative for themselves, that they've witnessed or experienced that through other members of their family or community.
Dan?
Yeah, as a lawyer, I started my career at Fitzroy Legal Service, and the very first case I did was a police accountability case. I remember going to the Moonee Ponds Magistrates Court and acting for a man who had been assaulted by the police, and it was only through some very lucky piece of evidence that came out about another investigation into one of the police members involved that he was able to have those charges, be acquitted of those charges, and subsequently I gave evidence in a county court hearing where the legal service represented him in civil action against the police, and the police changed their evidence in the county court, and my notes as an article clerk were persuasive in convincing the judge that their evidence wasn't to be accepted, and he won his civil case. But that was a very rare occurrence, and I remember even at that time talking to different members of the community, including Aboriginal people, and no one felt as though their complaints would be investigated seriously, and they were, as they are now, consistently referred back for local responses. And I remember we wrote back to the police who'd investigated this complaint originally that led to the criminal charges, and pointed out to them that two courts, the Magistrates Court and the County Court in the civil action, had found against the police, and they still dismissed our complaint on behalf of our client. And actually, when we spoke to them broadly about the lack of confidence in the complaint system, their response was, look, the numbers of complaints declining significantly over years, so it shows that we must be working well. So I think this is a long-standing problem, and I think efforts so far have indicated that that it needs to be institutionally, hierarchically separate from the police, and that's the position in other jurisdictions, and it seems to be a better system.
Thank you. And my second question related to the comments that you made about charter reform. One of the submissions you make is that the charter should be reformed to include a freestanding cause of action of some kind. If an independently enforceable cause of action were to be created in the charter, what would that mean for greater protection for the human rights of Aboriginal people?
That's a good question, and I think that, so in the ACT there's the standalone cause of action, and a recent example of that being used by a person in prison to assert their rights to be detained with dignity in the ACT allowed them to get declaratory relief that has then prompted policy change within the prison to improve the conditions within the prison. And so that's just one example of how a standalone cause of action can be used to help, improve the day-to-day life of people living in prison so that they're less likely to be subjected to cruel and degrading treatment and more likely to come out and be able to go on and start again and live the best life that they can. But I think that in itself, there needs to be more done in terms of, making sure that it's a standalone cause of action and the ability to access compensation if your rights have been infringed upon, and making it more accessible more generally would also be really useful.
Thank you.
Thank you. Thank you, Councillor.
Commissioners, I will now tender into evidence the following submissions. The first is the Human Rights Law Centre's Towards Ending Systemic Injustice and Transforming Victoria's Criminal Legal System, dated 7th of December 2022. And the second submission, the Northern Muyup to the Yoorrook Justice Commission on Systemic Injustice in the Criminal Justice System, authored by the Centre for Innovative Justice, dated November 2022.
Thank you. Those documents will be entered into the record. It's the next exhibit in those. Thank you, Councillor.
Thank you, Chair. I wonder if we might just break very briefly. I think the next witness was going to start at past, but if we could just have a brief interchange.
Thank you. Commence.
Thank you, Chair. We're about to hear evidence from our last witness for today, Dr. Eddie Cabillo. We should finish at or shortly after 4 p.m, notwithstanding the late start. I call Dr. Eddie Cabillo, and Commissioners, you'll note that Dr. Cabillo is in the witness box. Dr. Cabillo, could you tell the Commissioners your full name, please?
Eddie Cabillo.
And do you undertake to tell the truth in the evidence that you're about to give to this Commission?
Yes.
Dr. Cabillo, you've prepared an outline of evidence for the Commission, and I understand that you would like to read that to the Commission?
I'm happy to.
Please, we would be grateful if you did.
Okay. Just want to acknowledge that I'm on Wurundjeri country and acknowledge the elders, past and present and emerging. Also want to acknowledge those that have come before me and allowed me to do what I've done and present here today. So just going from my produced evidence here, I just want to say I'm a descendant of the Larrakia, Wajigan and Central Islander peoples of the Northern Territory. I'm a senior Indigenous Fellow at the University of Melbourne Law School, and I'm admitted as a legal practitioner in the Northern Territory.
I'm also an Associate Dean of Indigenous Programs, Director of the Indigenous Law and Justice Hub of the Melbourne Law School. I'll just give you an outline of positions I've had in the past, which will go towards my evidence. I was a former chair of the Yili Riang Regional Council of ATSIC, 2002 to 5, chair of the North Australian Aboriginal Justice Agency from 2006 to 8, Indigenous Director of NT Corrections between 2005 2007. I was a legal officer at the same time at the Northern Territory Department of Justice between 2004 and 2007, Anti-Discrimination Commissioner of the Northern Territory between 2010 and 2012, Executive Officer of the National Aboriginal and Torres Strait Islander Legal Service between 2012 and 2016, and Director of the Community Engagement for the Royal Commission in the Protection and Detention of Children in the Northern Territory, also known as the Dondar Royal Commission, between 2016 and 17. So, as an advocate and academic, I've written on issues regarding Aboriginal youth in custody, Aboriginal deaths in custody, and the biases of the Australian legal system against Aboriginal people. My PhD completed in 2021 was titled, "What Does Self-Determination Mean in the Context of Legal Service Provision for Aboriginal and Torres Strait Islander Legal Services?" My thesis analysed the complex factors characterising the environment in which ATSLs continue to survive and continue to achieve just outcomes for Indigenous people in Australia's justice system. The abstract to my thesis is available as attachment 1. The need for action in response to Yoorrook. It is frustrating that no one seems to be listening to the recommendations made by previous Royal Commissions and inquiries relating to First Nations justice. Yoorrook needs to be different. It's critical to build rapport with the affected communities before expecting people to pour their hearts out about these issues again and to follow through with action. People have done this multiple times, but no one listens. I've written on the toll of successive inquiries with no response on Indigenous people. In the article, the 30th anniversary of the Royal Commission Aboriginal Deaths in Custody and the white noise of the justice system is loud and clear, and that's also available in attachment 2. In this article, I noted, I have thought long and hard about whether this practice of appointing bodies and then ignoring them is a deliberate strategy of distraction designed to keep our people occupied and engaged with these serious problems, but always kicking a response down the road to some future government. Our human and material resources are always stretched thin. The demands made of us by these inquiries, especially on those who are already suffering, would only be worth it if they generated concrete action and meaningful systemic change. So far they have not. They have resulted in a rehash and rewrite of recommendations and themes that have been emphasised and repeated in all these past inquiries. So if you go back to the Royal Commission in Aboriginal Deaths in Custody from 87 to 91, there's a whole chapter on racism in the report. Very, very few people have read it. It looks at all the underpinning issues that affect our people and drive them into the criminal justice system. If someone revisited all those recommendations, we would see that they have all been redone that many times by other inquiries, but not implemented. These have been at least 500 First Nation deaths in custody since the Royal Commission handed down in its final report in 91. Even as recently as the Australian Law Reform Commission report, Pathways to Justice, inquiry into the incarceration rate in Aboriginal and Torres Strait Islander peoples from 2018, this has not been responded to or implemented by the current or former government. It's pretty current and no one is even looking at it or implementing it. It had 35 recommendations designed to reduce the disproportionate rate of incarceration of Aboriginal and Torres Strait Islander peoples and improve community safety. This is not even mentioned state and territory inquiries around children education, the justice system. Many have never gotten out into the community or taken up by government. We are always talking about these things, giving evidence, and no one listens. Government act as though the inquiry itself is the action addressing these systemic issues rather than a preliminary exercise to inform evidence-based action. It's an indictment and it's a kick the can down the road exercise to keep Indigenous people happy. Everyone gets involved in Royal Commissions and people hope for things to come out of them, but we've told these stories before and no one listens. This takes a real toll for Aboriginal people involved with these Royal Commissions and inquiries. As I said, I've worked on the Dondar Royal Commission as a Director in Community Engagement. We had a really short time period to act. We had 6 months initially, which wasn't even time to pull together staff and didn't allow us to get the best people. After the Dondar Royal Commission, and despite our recommendation, the government went the other way, and the change introduced was that kids on the streets after certain hours would be taken away from family. We're just given these recommendations on a silver platter and we just get more punitive measures. Why have these processes and inquiries and invest so much time, energy and money and recreate the trauma for these individuals involved if the government continue to respond with more punitive measures? Very few of our recommendations were implemented. They even changed the bail and sentencing laws to harsher straight after the Don Dale Royal Commission. Ultimately, the whole issue turns on the political vote. The public thinks that tough on crime works, even though the research and statistics tell us this isn't the case. Once you go into incarceration, you come out the other side and you graduate to being a better criminal. We've been making these recommendations for 32 years and something needs to change. In regards to the experience of Indigenous advocates, the work Aboriginal people do as advocates takes a personal toll on all of us. It is difficult working towards changing a system that is so stacked against Aboriginal people. People do not appreciate the sacrifice made or emotional toll of the work. We hear stories that cannot be unheard and often triggers our own trauma from our personal experiences. I've survived my advocacy work, but I'm scarred internally. In working on the Don Dale Royal Commission, I saw the intrusion of these policies that continue to disrespect our values, our people and our culture, and which won't allow our people and our culture to address the problems that we know how to deal with. After returning to the NT for the first time after participating in the Don Dale Royal Commission, I was approached and treated with hostility by Indigenous people who did not see any indication of real positive change as a result of the Don Dale Royal Commission's investigation. Within hours of being home, I was confronted, subjected to obscenities and physically threatened by Indigenous people in relation to my role in the Commission. A copy of an article I wrote titled On the Personal Toll for Indigenous Advocates and People When Governments Fail to Act that refers to this incident and discusses these issues is available in the attachment 3. Our Royal Commissions have huge mental health impact on the staff. On the Don Dale Royal Commission, we were provided with counselling on the job, but you don't necessarily need it on the job because you're surrounded by people and debriefing with colleagues all the time. But it's when you're gone, you don't get that support mechanism anymore and you need assistance. You're in your family home and no one understands what you've heard and what you know. My experience was that I needed psychological assistance after the Royal Commission was over and I was no longer an employee, but I was told they no longer covered this assistance. Former Commissioner Mick Gooder lobbied on my behalf to get further cover, but by the time they got back to me with an answer, I had already engaged with my Aboriginal medical service who provided me with assistance. These issues impact staff and community constantly. Indigenous people have a lot at stake when participating in these sort of advocacy. We have a huge responsibility to our family, extended families and community. It's not a game for us. It is our family and our kids' lives that are at stake. Our mob keep hearing promises, but those promises have not led to real implementation to make change. This needs to come across in the recommendations made to government, namely the importance of implementing and acting on Yoorrook's recommendations that it needs to be bipartisan. The racism in legal systems. I have been impacted by trauma, colonisation and systemic racism. As an Indigenous person with white settler law qualifications, I've heard in academic and legal institutions how the law is supposedly fair and just. And that doesn't resemble what I've experienced in my life. I've seen personally from my experience and on the Don Dale Royal Commission how unconscious bias plays a big role in impacting outcomes for Aboriginal people in the white settler system. I've written a PhD on Indigenous legal services, writing from an Indigenous perspective and how my life and experience reflects what the system does for our people after dispossession. I will share some stories on bias I've personally experienced in the legal system to demonstrate that my qualifications and positions do not protect me from experience of blatant racism. When I started as an admitted lawyer in the courthouse in the NT, the first day I arrived to represent clients in the court as a legal aid lawyer, the court orderly asked me to move from I was sitting to sit behind my lawyer. She assumed based on my appearance that I must have been a client rather than a lawyer. I told her that I was a lawyer. A short while later, another orderly came over and asked me the same thing. Again, this still persists. 22 years later, the same thing happened at the Don Dale Royal Commission. I was sitting in court with another Indigenous lawyer who just recently gave evidence. I told him that the court orderly was going to come over and ask if we're in the right place. Sure enough, the orderly came over a short time later to ask if we're on the list, if we're in the right courtroom. My colleague shows them his Royal Commission ID and we walk out laughing to ourselves. But that's the only way we can cope with these things. We're angry and hurt, but it's so constant that you you can't do anything but laugh. How do we get justice when you're already judged based on the colour of your skin? This is the racism of this system. In my role as Assistant Dean at the Law School at the University of Melbourne, I was moving some boxes to a different office within the faculty. On my third run, a student asked me to come and clean up his coffee that he had spilled. He thought I was a cleaner based on my appearance and I was carrying boxes. It happens all the time. People will follow you on campus asking what you're doing there. It's hard to accept the racism at the university. It's like a betrayal working with a curriculum with such silence and omissions. Knowing it will have an effect on our students and that the students will carry this into their actions in the profession, perpetuating cultures of legal institutions which harm Aboriginal people. Recently, I was pulled over by police while driving in a wealthy eastern suburb of Melbourne. I heard this described as the offence of driving while black. The police searched my car while I was sitting on the sidewalk in the rain. During the search, they asked me what I was doing in the suburb and asked me how I afforded my car. I would have challenged the police's behaviour if I hadn't had the experience I've had, but I know that as a black man you have to act a certain way to protect your safety. Throughout this ordeal, my anxiety was really high, even though I know I had done nothing wrong. These individual biases and decision-making means policies and laws affecting Aboriginal people differently to non-Aboriginal population. Aboriginal people are overrepresented in all areas of the criminal justice system. Our women are the fastest growing proportion of incarcerated people. This has a particular impact on our family dynamics. Men have been incarcerated for so long and the women have been at home looking after the family unit. What happens now when they are being locked up too? The trial of Zachary Rolfe marked a historic moment in accountability for Aboriginal deaths in custody. This was the first time a police officer faced a murder trial on Aboriginal death in custody case in the Northern Territory since the Royal Commission to an Aboriginal deaths in custody. I wrote an article on this case with Professor Thalia Anthony titled Kumajay Walker Murder Trial will be in first in NT for an Indigenous death in custody. Why is it taking so long? Which is available again at attachment 4. When Rolfe was found not guilty of murder and other charges by an all-white jury, no Indigenous person thought there would be a different result in that case. At the cranial inquest in Kumajay Walker's death, I attended the proceedings to observe a number of the police officers in Alice Springs give evidence. The police officers given evidence basically all said they had never heard or observed any racism in the workplace. But I saw a police officer break ranks and give evidence about against them in the police force. The police commission told that the officer they wouldn't represent him anymore. They've had to find his own lawyer. The blue line was really apparent with the police. At the part of the inquest that I attended, the majority of Indigenous people present didn't enter their courtroom, and I believe this was because of the large police presence observing the proceedings. Instead, Indigenous people present stayed in the park outside and waited for updates. There are, however, a lot of positives about how the inquest was run. The counsel assisting the coroner, Peggy Dwyer, did a good job in engaging with Aboriginal people and preparing parties to tell their story. Time wasn't wasted and people were left weren't waiting forever. There was a unique welcome to country which really set people at ease and really you could tell that it really meant a lot to people in the courtroom. The fact of the matter is if you lock up vulnerable people, especially in a biased system, the risk of a tragic death in custody is increased. I wrote about this in an article titled Aboriginal Deaths in Custody, NT Paperless Arrest, Police Powers Need Urgent Review, available at attachment 5. If we want to reduce the number of Aboriginal deaths in custody, we need to reduce the rates at which Aboriginal people are taken into custody. This was the core of the recommendations from the Royal Commission to Aboriginal deaths in custody. Custody should be used as a last resort for the most serious situations and only where absolutely necessary. The importance of culture. Culture and kinship are strengths which help us to survive this kind of thing. They need to be acknowledged as though through our policy settings and our administrative system. So when my parents split up when I was 1, I lived with extended family. This enriched my cultural life and therefore supported my well-being. This isn't afforded to our people in the same way anymore. We don't get to rely on kinship. We have people evaluating our home lives and what is best or most suitable for us. If it wasn't for staying with family, I'd never would have survived the breakdown of my immediate family. It traumatises you each time a family breakdown happens, but I was nurtured and guided by my cultural kinship practices and my uncles would take care of me. Changing law, school curriculum and legal accreditation. So I'm currently an academic staff member at the most prestigious law school in Australia. I think out of there comes 4 Prime Ministers, 14 High Court Justices, and it troubles me that most graduates have no clue about Indigenous law. The reality is that there is no real push in the profession for systemic change. We have students coming out of sandstone universities, they'll become leaders, they need to have an understanding of Aboriginal issues. When I was in New Zealand recently, I met university deans who spoke about Te Reo Māori without blinking an eye. There is real Māori immersion in New Zealand throughout their curriculum. There's an acceptance that Māori are traditional owners. They're a very long way ahead of us. Further, the regulator of the legal curriculum in New Zealand has recently announced their introduction of a requirement that all law schools must teach Tikanga Māori. We get great turnout at our events at the Indigenous Law and Justice Hub and great engagement by students in our classes. Our students are for learning about First Peoples in Australia, but we're not giving them the information they need to work effectively alongside Indigenous people in their justice system. Our profession needs to accept that we need continuous education on these issues. Our position is that in the context of the small number of Indigenous academics, all teaching staff have a responsibility to teach Indigenous content proficiently, and that we as the institution need to support teaching staff to do this. We currently have a small grant where we're investigating how to support our teachers to develop these capabilities. My experience is that universities, we teach the law, but we don't teach the reality of the law a lot of the time. Additionally, my experience is that some teachers bring biases into the classroom. Their omissions and narratives dictate how they frame their clients. By the time the students get into practice, I fear they have it ingrained in their heads that Indigenous people are problematic, that they are trouble, not that they carry intergenerational trauma or have complex needs. In December 2020, the Council of Australian Law Deans released a statement condemning the systemic discrimination that permeates the Australian legal system with respect to First Nations people. The Council of Australian Law Deans acknowledge that part that Australian legal education has played in supporting the law's systemic discrimination and structural bias against First Nations people, while noting that the positive contribution that law schools can and should make in partnership with First Nations peoples. The Court called on all Australian law schools to work in partnership with First Nations people to give priority to the creation of culturally competent and culturally safe courses and programs. A copy of the call statement is available at attachment 6. Part of the problem is regulation of legal education. In the Priestley 11, the core subjects required to do a law degree, not one of these subjects is Indigenous, and no content is required to be delivered with any Indigenous lens or content. As a result, many students go through 3 or 4 years of university studying law without being taught how the law systemically impacts First Nations people. The curriculum is racist and it needs changing. An article I wrote on the issue around the Indigenous content in legal curricula titled Indigenous Programs at Law School is available at attachment 7. In that article, I note that such content is lacking, and where it is included, efforts to date have been fragmented and sometimes tokenistic. At the Melbourne Law School, I've been involved in a curriculum review seeking to incorporate Indigenous content in the Juris Doctor law curriculum. Firstly, we approached legal methods and reasoning, a 10-day crash course on legal principles, and we have indigenised that and received a lot of good feedback. Now we're focusing on the Priestley 11s so students can have an idea about the predicament of Indigenous people in this country. Again, we've got a small grant to train a trainer in a law school around delivering Indigenous content, acknowledging that teaching staff need to implement these changes. Information on this review is also available at attachment 7. We're also delivering a new elective subjects, including on-country learning experiences for law students to enhance their understanding of First Nations people and law. Our aim is to ensure that all students have a baseline understanding of Indigenous experience of law and skills for working safely with Indigenous clients, while also providing opportunities for real depth of learning through specialisation. I recommended that the Law Council adopted a 12th Priestley unit with a unit on Indigenous history and a law made compulsory to graduate with a law degree. I recommended something aligned with Call to Action 28 from the Canadian Truth and Justice Commission, where they say, we call upon law schools in Canada to require all students to take a course in Aboriginal people and the law, which includes the history and legacy of residential schools, the United Nations Declaration on the Rights of Indigenous People, treaties and Aboriginal rights, Indigenous law and Aboriginal Crown relations. This will require skill-based training in intercultural competency, conflict resolution, human rights, and anti-racism. In line with Canadian Truth and Justice Commission Recommendation 27, I also recommend that lawyers should be supported to work with Indigenous people through ongoing training and accreditation post-admission. As explained in an article by Sandra Shutt in the Canadian Lawyer titled TRC Officer Window of Opportunity for Legal Education in 2015, the Canadian Truth and Justice Commission recommendations 27 and 28 show that there are substantive elements of the story of Indigenous settler relations that are essential for understanding what it means to be a legal advocate, law student or lawyer today. And that gaps in existing knowledge have caused harm. A copy of this article is available at attachment 8. I do not believe that there is an appropriate regulatory incentive or market availability of ongoing professional development, education for cultural capability and cultural safety training for lawyers. Working with Aboriginal and Torres Strait Islander people, this is a barrier to effective access to justice for Indigenous Victorians and is unsafe. When New South Wales Legal Aid was run by Brendan Thomas, an Indigenous man, if you wanted to work there as a panel, as a firm, you need to have an Indigenous accreditation, and they would do evaluation and surveys with clients about how they rated their practitioners. This should be mandated and rolled out everywhere for lawyers working with Aboriginal people. I was at the IATSIS conference in Queensland this year, and Justice French and North both said that they did not have appropriate knowledge of Indigenous people to perform their duties when they were appointed as judges, and that they were still learning towards the end of their tenure. This bolstered my determination that things need to change. Our solution and reforms, perspectives on Aboriginal issues need to change. Australian people should have an understanding of the trauma that continues to affect Aboriginal people. These traumas and stories and the hiding from police continue to happen until we see proper change. We need to start with this early in our education systems and carry it through institutions such as universities. In Darwin, if you get on a plane and leave for a hospital, people think you're going there to die because you don't come back. There are real stories and experience from our mob. We need the broader public to understand these experiences to get over the systemic and unconscious bias against our people. Many of us mob working in Indigenous advocacy and taking on a toll of the work as Aboriginal people are saying the same thing in terms of asking other Australians to stand with us. After the Don Dale Royal Commission, when they changed the bail and sentencing laws in the Northern Territory, we wrote to them saying it went against the recommendations from the Royal Commission. We spoke to one local member at the time who had supported us, and she replied saying she listened to her constituents. She was worried about her constituents and worried about keeping her seat. This is really disappointing. We won't get anywhere until the wider public has a sympathetic view that Aboriginal people are not getting a fair go in the justice system. We're only 3% of the population, so we're not an impactful voting group. We rely on the public to keep government accountable. The public wants to see tough on crime, but they're not across the fact that locking people up doesn't make them any safer. Our politicians don't understand it either. If we really want to make change, it needs to be better understood. Biases and structural racism need to be accounted for. We all have them. When we have new governments, we don't have a new bureaucracy. They make the same racist decisions. The same people decide whether we get welfare card or if our kids stay in our houses or not. That's where the issues are. The same people write the policies. Need for better accreditation in legal industry. Well, like I said, I'd like to see it come from Yoorrook's recommendations that people working in the justice system need to understand Indigenous law and LORE, as well as basic competencies and understandings for working safely with Indigenous people. The accreditation or CPD points need to be ongoing, and professional working with mob should be accredited. Judges who work with Indigenous people need it as well. These were the recommendations implemented out of the Canadian Truth-Telling Commission. If we get the ball rolling in Victoria, then we can provide something for the rest of the country to point to. Reimagining goals and policies around the criminal justice system. Currently, the reality of the criminal justice system centres around control, coercion and punishment. A reimagined system would be more reformative and focused on rehabilitation, looking at the trauma and the factors that contribute to the behaviour. Laws and policies can have a profound impact and be implemented immediately. If you can get rid of bail and sentencing reforms and raise the age, these policies all make change straight away. There need to be other options around sentencing. Mandatory sentencing has impacted on judges who adjudicate the law, and separation of powers have basically been breached. These changes are simple and would make a lot of change. Indigenous legal services. We need to appropriately fund Aboriginal legal services, enable access to justice for Indigenous people. The tough on crime approach in Australia increases the work for Indigenous legal services, and they're not being provided with enough funding to manage this increase. Aboriginal legal services are the most culturally safe place for Aboriginal people to go to, but there's a very limited funding. Government policy has been services moved away from being community controlled to adopt a standard corporate governance model. I'd just like to touch on treaty. With frameworks, the governments can consider whether they are willing to negotiate and relinquish with regards to what treaty can allow Indigenous people to do. But also Indigenous people cannot take something on that alleviates the government of their responsibilities. The treaty should be a living document that is flexible to achieve the best outcomes for everyone. It can help build a respectful relationship between government and Indigenous people, as Indigenous voices need to be heard at every level to make changes. For better outcomes for First Nations people, we need to move to genuine self-determination and shift decision-making powers to First Peoples. To prevent our people coming into contact with criminal, legal and child protection systems, we need to address disadvantage, discrimination, disempowerment by improving outcomes in health, education, housing and employment. And that change happens when First Nations people are in control. This will happen by redesigning of both child protection and criminal legal systems must be part of the statewide treaty negotiations. First Nations people should be the ones designing the systems that affect them. The treaty process can deliver this. The Victorian government should make investments now to resource First Nations peoples and experts to thinking about the redesigning of these failing systems. This could be done by resourcing the Assembly to work with the ACHOs and the communities to develop aspiration and priorities to shift decision-making to First Nations people. Integration of Indigenous laws. Aboriginal people have laws that is not recognised as laws or embraced as a source of meaningful justice in Australia. In my recent travels to New Zealand, I saw how tikanga, being Maori law and customary practices, are increasingly being incorporated into the common law and grappled with by courts. The Waitangi Tribunal has a broad scope in New Zealand to make findings and recommendations on historical and contemporary breaches of the treaty with First Nations people, including in relation to tikanga. We are far off this in Australia. We need more writing from our people on models of legal pluralism to enable recognition, Indigenous laws, and if appropriate, some integration of legal systems. The common law in Australia is meant to be flexible and reflect our community values. It should be able to evolve to accommodate the presence of Indigenous legal systems. Importantly, this needs to be done in a way that does not deny the validity of law and culture which have evolved since first contact, as this legal system so often does. Urban blackfellas have their cultural beliefs, practices and identities. We've been teaching it in history that the real blackfellas are those running around in red underpants with a spear. But no culture is stagnant. Indigenous people have been adapting for years, and yet we expect it to stay the same to whitefellas. That's a racist point. I think there's evaluation and that the underpins what a justice space should look like. We need to look at where we made wrongs in history in the legal space. Just finishing off, needs for action on Yoorrook recommendation. There needs to be a follow-through and investment in rolling out of recommendations to community. Even at the stage of letting community know where the recommendations were and any commitments by governments. People have invested themselves to tell their stories and no one gets told what the outcomes are usually. I've seen that happen before, but it shouldn't happen. If you're lucky and have a laptop and Wi-Fi, you might be able to download it. My hard copies are currently sitting behind me and no one uses them, and communication needs to be rolled out in a way that is relevant and accessible to First Nations people.
Thank you.
That's it from me.
Thank you, Dr. Cabillo. I might just ask you some questions in relation to the Dondale Royal Commission. That commission was initially given a time frame of 6 months. You would agree with me that that was an unrealistic time frame?
Did you say 6 months?
6 months. It's then extended to 12 months. This commission of inquiry is convened as a Royal Commission, and it has a much lengthier time frame. Do you see that lengthier time frame as some benefit to, in terms of ensuring action upon the recommendations. Given that the Commission proposes to issue an interim report, the Yoorrook Justice Commission proposes to issue an interim report next June in relation to the priority matters about which it's hearing evidence at the moment.
Excuse me. I see it. Obviously, like 6 months, as I said in the statement, that to bring together the actual workforce is it takes some time to pull people together, to get commitment from people to come and work on a Royal Commission. It's a short term, like even like 3 to 4 years is really hard to get people to commit and leave jobs that they're in. So any sort of time frame is difficult. And again, we're dealing with trauma and people that have continuously faced and presented themselves to give evidence on like I said, numerous occasions and that trauma is revisited each time. And then people are reluctant, and then it puts pressure on the actual vehicle to get things going and to meet these deadlines that are put there by government with no real understanding of what it takes to work in this space. And like 4 years is definitely way longer than our 6 to 12 months. But the reality is, we're dealing with intergenerational trauma that people have lost people on that journey and are reluctant to come forward and to encourage people to get forward, to build a rapport and trust from the Commission to the community is also a big thing as well. And also that educational process that you need to do with not only the Indigenous community, which is pretty across what happens in these things, it's trying to build that with the non-Indigenous community to get them to understand the processes and what you're trying to actually get out of such a huge, ordeal in regards to a Royal Commission.
Thank you. The Northern Territory government largely accepted all the recommendations of the Dondale Royal Commission, and then didn't take much action in the way of implementation. In this process, given that it's over a lengthier period of time, there is the ability to recall ministers and departmental heads and subpoena documents and to hold them to account as to why particular recommendations haven't been implemented during the course of the Commission. Do you think that presents some hope in terms of holding government to account?
We've got bipartisan support here at the moment, and that does have some strength in it in regards to reinforcing the recommendations. However, I think, as I pointed out here, and like Monday and Tuesday I was in Canberra on the National Justice Policy Partnership discussions, and for me personally, the reality, as I've mentioned in here, is the power, the political power and the vote. Bottom line is, in the end, every political party wants to get re-elected, and the difficulty is tough on crime is usually a vote winner, which makes that difficult. But here in Victoria, I see the possibilities with the treaty on foot and the treaty authority being in place, the possibilities of reinforcing the recommendations that come out of Yoorrook could possibly be a lot stronger on either political party when in government to follow through with what's happened. So I think it's a lot more encouraging here in Victoria at the current time, which, as an Indigenous person who's worked in this space, I see that as a positive.
I just want to ask you a question now about the racism that you've talked about in your statement. The heading that you've put in your statement is racism in the legal system, but some of the incidents you're talking about are just racism generally in the population.
Yep.
And so can we take it that you're pointing out to the Commission that racism is fairly rife and widespread in the population? Is that your view?
Yeah, look, in some of those attachments that I handed up, that's not only coming from an Indigenous person. We have former Chief Justice of the Supreme Court saying that the system is systemically racist. And as a former anti-discrimination commissioner and hearing the evidence from the previous people, that I've had people come knock on my door, Indigenous people, and tell me about all the racism that's rife in the community and within our systems, who aren't willing to lodge complaints because they know the system is right against them, and not willing to be subjected to the system, but also of it failing them yet again. I think as a parent and a grandparent, and I'll show the Indigenous commissioners that we hear that our grandparents went through this stuff so we wouldn't have to face it. But unfortunately, we face it constantly, and I gave just a couple examples of being at school, just driving home, and working in the court system. Just as about a week ago, I got locked out of my uni room because I left my ID card on my desk, and I asked someone to let me in so I can get in, and basically they wouldn't let me in until I told them I was the associate dean, and then they stood there and Googled me and checked my photo against me, and then they were satisfied that I said who I was. And I'd suggest they wouldn't do that to a non-Indigenous academic. Yeah, it's pretty rife, and I think it's constant, and you just, some days it's difficult, but we, as our elders have done, we just got to continue on doing to try and make that change.
And with that recognition of broad systemic racism within the community, does it come as a surprise to you that the legal education system, the law schools, have difficulty even themselves recognising their failings in terms of inclusion of Indigenous material through the law degree?
When I got to Melbourne Law School, there was 8 JD students, and now there's some 30 odd, and I've been there 5 years. But
Indigenous.
Yeah.
Yeah.
And like, just to give you we have 500 come in the first year this year. So, those are considerable numbers. And like, I go and listen to lectures, and I've been asked, what do I think? And I say, yeah, he taught the law well. And in this case, it was criminal law. But I said, but I'm not sure he's teaching the reality of the law. And when I say that, I mean, like I said in the discussion, that in the evidence, that he's defending the client, but he's talking about how they're problematic, they're troublesome. And you say that enough times in 3 years, you start to believe that, right? And if you don't qualify why they're troublesome or problematic, you never really have an understanding of what the current issues are and why the individual is in front of the court. So I think there's a real problem if that's, and I heard from the previous evidence that, an alum of the law school said they never received that type of teaching and that. And it's apparent when you got people doing undergrad and they get to, say, the law school and they read my paper on the 30th anniversary of the deaths in custody, that when they're talking to you in the class, they're unaware of how racist the system is. And these students, they've had the best teachings and will become great legal advocates, but not in a space where they will deal with Indigenous peoples because they have no understanding. They've never been hungry or never had to share a bed or gone homeless for a while or something. So it's foreign to them, and where somehow that understanding is lost. And if I go back to my PhD, I interviewed lawyers and prosecutors and judges, and they're saying that, an example that one of the prosecutors gave me was that the young defence lawyer was reading the précis rather than talk to their client. And the client was in the box, who's probably more skilled at the legal system because they've been there a bit, was saying, that's not what I told you. And so the judge had to, stop proceedings and ask them to go and speak to their client. And I heard that several times in my interviews and similar stories, and I think it starts to become a problem when we're not talking to our client, and we have no ideas on how we relate to low take colour out of it, relate to low socioeconomic peoples, and the world that they face, and then that really puts the advocacy right behind the 8 ball then, and we have real issues. We're currently doing engagement with VLA, Victorian Legal Aid, and LIV, Law Institute of Victoria, discussing around CPD and ongoing accreditation for lawyers practicing in Indigenous spaces. And as you know, Tony, I've had huge discussions at the Law Council Indigenous reference group about how we do that Australia-wide. So we're hoping that Victoria could lead the way there, and that's why I mentioned it in the evidence that those are possible recommendations that I'd called for. And I think I don't want to be disrespectful to anyone, but we have as many black lawyers and justices in this country than we've ever had, but we also got as many people incarcerated and children at a home care. So the system is not working, and so there needs to be some real leadership from, I suppose, from the Commission in regards to its recommendations, but also from governments to make sure that they implement the recommendations that come out of here.
So, Eddie, you've talked about the CPD and the accreditation there. Should law schools themselves be accredited? An Indigenous accreditation body that actually accredits law schools courses in the same way they have to do the priestly 11 and other things?
Well, like I said, the Council of Australian Law Deans have called it out and said that things need to be better than what they've been in there.
Yeah, but we can't start with a 20-year voluntary process.
No, but I think if we get recommendations like they did in Canada, we can start to really reinforce and push the Council of Australian Law Deans to follow through what they said, and also have the profession start to really stand up. And in some places the silence is deafening, but in other places they're really, there's spot fires everywhere, people trying to do the right thing, but it needs to be a real push from key places like government and the profession itself. The law schools definitely need to do their part.
You've really painted a picture that you're attempting to take on the legal academia and hold a mirror up to it and force some change in that area. Do you sometimes feel frustration that you should have to do it and that they can't figure it out for themselves?
Well, where I am, there's 120 plus academics, and there's 2 Indigenous. So the job is frustrating. There's a lot of pushback. Academic freedom is widely thrown around. And like I've heard 1 or 2, people say, well, the Council of Australian Law Deans don't represent me, So that's the environment we're working in. It's very hierarchical. And that's just with people up front, talking to you up front. There's a lot behind the scenes that you hear secondhand. And I've been around a bit, so I've worked, as you've seen some of my CV, but so I'm able to utilise my networks that I've developed over the years to help me when there are, certain issues in that. But what worries me is younger people who work in these environments, and also our students. You sit in class and we hear, the way that's taught and sometimes it's really confronting, and it doesn't represent how the law and that is in your life. So it's constant, and you try and develop your own mechanisms, tools to assist you through that process. But others have been there before, and that's why I said I wanted to acknowledge my elders and those who've been here before. But it's a very slow change, if any, at times.
Thank you. Commissioners, I don't have any more questions for Dr. Cabello in relation to his statement. Are there any questions that...
Yeah, I do, Council. Dr. Cabello, you were talking earlier about racism just in general, being asked to go in and showing your ID and things like that. So that's just on a day-to-day basis. Within the structures that you work in within the law school, and you're talking about the curricula having no cultural overlay or underpinning, would you say it's racist?
Like I said in the evidence, that there's very little in some of them.
Have you started to roll something out with the law school, something with other? You said that you've got some money for a train the train or what have you, but have you started doing or thinking or piloting something with lecturers there or professors and people teaching subjects? Has anything started to be rolled out with them, and if so, what's the response to that?
What we have done, where myself and we've been able to grab other Indigenous academics or lawyers to come in and do the do's and don'ts when teaching on Indigenous content, and have open sessions where they can chat and we can ask questions in a safe space, and that's been appreciated by those who attend. That's not always happening. We've also engaged with Ruben Berg from who runs a cultural business, and he's delivered to the law school on various Indigenous cultural information, which is also well received. We've also had a racism training, which people they're not instructed to attend. You have to volunteer to attend. And there's one on racism, and then there's one specifically for allies. We've done that. And
Are they voluntary, both?
yeah, so you can't, if you force people there, they won't participate anyway. So, but it was well received by people. Did turn up. Obviously, not everyone, and they provided made it flexible for people to attend. And we also, again, with those grants, we're developing a train the trainer type program, and hopefully we can roll that out with the conjunction of indigenising our priestly 11 subjects.
Do you think for all universities, and we'll call it for the sake of frontline workers, social workers, police, nurses, there should be within all the curriculum and all the courses in universities that will come into contact with our people? Do you think there should be something within each course?
Yeah, I think so. I think, obviously, I'm not saying we're doing it the best or anything. I know there's some other law schools doing it as well, doing things. Usually, the health stream and medicine do these things better than us, and I'm not saying that space is perfect. What I'm saying, but if we look to our cousins in the health space, if you're a nurse and you want to work in an Indigenous space, you have to get accreditation, and I think, those sort of things are something that we should really look to. I wrote a chapter in my PhD which didn't make the cut, but I looked at the health and justice space, and looked at particularly the Close the Gap vehicle, and which allowed health to be at the table and to initiate them to be involved in key policy movement, as well as have that debate with the profession, within their profession, and I think that's allowed them to have some movement and change. Where unfortunately in the justice space, we initially didn't make the cut for Close the Gap to have KPIs. We had our national partnership agreement, which no state or territory really took up in the end because there were no new dollars attached to it. So out of the decade of Close the Gap, the justice space sort of wasn't involved in those. There were all these key areas where they met and discussed key policy changes within government, and I think the National Justice Policy Partnership is sort of like a precursor of that now. It's sort of following that road, which is a long way off. They're heavily reliant on, I don't know if it's still called SCAG, the meeting of all the Attorney Generals across the country. So, the discussion around raising the age, we've had some movement with the Northern Territory going to 12, with the possibility of going to 14 down the track, and hopefully some of the other states and territories would move to 14.
Commissioner Bell.
I want to ask you a question about whether law schools are culturally safe places for Indigenous students. You've described your own personal experience, which makes me doubt that. I've just come from working in a law school, and I was informed that there were 25 Indigenous students enrolled in undergraduate law who identified to the university, but only 5 identified to the faculty, so I did not know most of them. I wonder if you can comment whether more can be done to make law schools culturally safe places.
To answer your first question, I have numerous discussions with students around things in class and outside of class, which would say to me we're a long way from being culturally safe in these places. And the numbers tell you that as well. And a lot, and I'm just speaking for where I'm at, the law school I'm at, I don't get to know all of them because they don't make themselves known to you. For a whole lot of reasons. Because I speak to non-Indigenous alum of the law school, and a lot of them tell me they've never been back because it wasn't a nice place for them. And I spoke to non-European students who also have some issues with the safety of the environment that we're in. So I'd, and look, where I am, I'm the director of the Indigenous Law and Justice Hub. There's 4 staff members, and there's no pastoral care person. And it's because it's a post-grad, right? It's not an undergrad unit degree. So there's all these, most of the thing for looking after Indigenous students are about undergrads or government funding on that. So it's difficult. And unlike health, where people bequeath funds and are happy to donate to, lawyers aren't. Law firms, they're happy to do pro bono, in-kind sort of thing, but they don't like to donate funds. So it's really hard to, assist students through university, Indigenous students who come from outside of, Victoria, or even from the country, right? It's hard to assist them if you don't have the ability to do so. Like we were on a trip and someone's grandfather died, and there's no way, the cost and all of that, and trying to assist in that. To do a PLT, it's 10 grand after you already paid 40 for your degree, and not even. So it all adds up, and we could be. A lot of Indigenous students and then non-Indigenous students struggle because of the cost of those to become, practicing lawyers.
Yep.
So there's this whole culture within some of these places. Not just, there's an elite, wealthy culture that is also. Compels the racism in these places.
Dr. Capillo, just carrying on from Deputy Chair Hunter's questions. You're aware of the developments in New Zealand in relation to the proposals to incorporate tikanga Māori into the undergraduate law system, and a review of a review of the whole of the curricula to make it consistent with the notions of a bi-jural legal system.
Mm-hmm.
Is that something that also needs to occur in this country?
Yeah, I mean, look, I've had heaps of discussions with this, and like, I mean, the system that's currently in place, one could argue that it's here on a lie, and if we go up home or you go out remote, people are still practicing their laws like they ever have. I've got some family living in community that haven't seen a non-Indigenous person for several years, right? So, I mean, it obviously can happen. It's happened elsewhere in the world, and we've had so many customary law reviews that don't see the light of day, and we have people writing on it, and there needs to be some serious consideration from where we go from here on. I think if we're talking about treaty, and we're talking about a national voice, and we're talking about a republic, which, you know, we need to consider First Nations laws, and we need to be adults about it to understand that our people's first thing is to their law and their culture in most of our lives and places. So, and I'm not just dispelling, like I said in the evidence, our urban people. I've got an urban nation that is on the peripheral of losing its language, but also rejuvenating a lot of its practices as well. And that's happening all around the world now. And I think as a nation going forward, these are some serious things that we need to consider. I mean, the tikanga stuff and the case of Alice, as I've put in the footnotes here, is it's mind-boggling when you think about it, you know, and we're just across the road from them, and you just wonder why are we so unlucky to end up with the form of colonialism that we had in comparison to what they have there. And I'm not saying it's perfect over there, because their incarceration rates are similar, but touring around with 19 students 2 weeks ago and looking at tikanga and speaking with, you know, the likes of Joe Williams and Judge Farah and others.
You're referring to Justice Joe Williams of the Supreme Court of New Zealand?
Yeah. And to see how they adjudicate, but also walk in two worlds and be able to do that with the understanding of their Māori tikanga and their mana and all that. It's really sad to see where we're currently situated in our country in regards to that. We're not even trying to teach it in our law schools to give hope to change the logic and thinking in our legal profession. And I was talking to our dean on one of the trips when we were over there. He came and spent a few days with us. That the legal system brags that the common law is flexible enough to move and accommodate all circumstances. And that's really confronting for an Indigenous person to think like that. But the reality is the common law is basically customary law, right? Mm. And this is the thing with our law in Australia. We forget, we don't put importance on the history. And the history is that this law derives from customary law, and that all we ask is that you accept our laws, and so for me, it's an interesting discussion and one that this country needs to have. And I think, some of the circles that we're involved with that they're very dismissive on the discussion. And that, for me, that's a problem. We can't even have the chat, then there's obviously, we're a long way off from making real change in the justice space.
Thank you. I have no other questions, Deputy Chair. I tender the witness outline of Dr. Eddie Cabillo, which is document 8.5, and the documents following in the tender list and referred to in Dr. Cabillo's outline and his evidence.
Thank you, Mr McAvoy.
Dr. Cabillo can be excused, Deputy Chair, and that concludes our evidence for today.
We'll now adjourn until 10 a.m. tomorrow morning. Thank you.
Thank you.